Any adjournment request? Daily list for admission. Item number 1.
May I please, Your Lordship. My lord, this appeal preferred against the order of acquittal, man. Son of the deceased, my lord, is the appellant here. Some charge-sheeted witness was not examined, and my lord, some charge-sheeted witness was not examined, and my lord, doctor also not examined. Even charge was framed 302. The postmortem report also not exhibited, man.
Postmortem report.
Yes, ma'am. Not exhibited. And some eyewitness, my lord, they call the learned court is not considered as the eyewitness, man. All the 18, 17, my lord, were acquitted, man.
Where it is mentioned, postmortem report is available, not examined, or doctor, anything is there?
My lord, my lord, page 43, my lord. Well, the exhibit not mentioned here, the postmortem report.
When is the date of incident?
My lord, date of incident, my lord, 2010-2011, my lord.
And where is the reflection that somebody died? And when died? Who died?
After 15 days, my lord, in the hospital.
After 15 days.
Yes, my lord.
Where is that fact?
Immediately he was admitted in the hospital. Yes, my lord. My lord, page 25, my lord.
25.
25, my lord, first paragraph, last line. Akabur Ali died in GMC after 15 days.
After 15 days. So any ZD entry, any FIR, when FIR was lodged?
Affair was lost, my lord, immediately after sustained injury, my lord. Affair I have not annexed, my lord. On the same day, my lord. On the same day.
Same day means?
Same means, my lord, 2010-2011, my lord.
2010. 2010.
20.
20.
10.
FIR was 2010.
Yes, ma'am.
Incident was
Same day, ma'am.
no. How can it be? You just said
Morning, my lord.
it is
incident.
10-10.
One typical mistake, I think, my lord. I have seen the judgment somewhere. Somewhere, my lord, wrongly typed that incident showed 10-10. In fact, 2010.
No. And then see paragraph 5, the charge,
My lord, in judgment.
the charge, point for determination. Whether on 10-10-2011.
Yes, ma'am. That is, I think, wrong, my lord.
So unlawful assembly.
Page 21.
Then again, paragraph 7. This is another date, 12-10-2011.
But in first page of the judgment, page 21, find the
That is FIR
yes, madam.
on the same day. That something is wrong.
But the copy of the affair also we get, madam.
Hmm.
Affair is there, madam.
It is incident is 2010.
Yes, madam. 2010.
Huh?
2010.
FIR as per FIR?
As per madam, 2020.
FIR was lodged on 2010.
Yes, madam. No, that
When was the incident?
incident that very day, madam.
Let us see.
Morning incident was happened.
Let us see the FIR.
Yes, madam. You take the picture, okay? I'll do it. Early August, 3:30.
And postmortem was done or not?
Yes, my lord, postmortem was done.
Is there any reflection here in a judgment?
My lord, in the judgment, nowhere reflect about the postmortem,
Hmm?
not discuss, my lord, the judgment.
In your memo of appeal?
Appeal, my lord.
একেবাৰে লিখিছে বাৰু এফআইআৰত 15 দিন পিছত মৰিছে Deceased. Paragraph 30 also. Name of the disease in the inquest report and name of the disease in the postmortem are not the same. Hmm. Hmm. তাৰপিছত 32 টো আনিছে 32 The son of the disease himself is not
What?
making any statement as regards the injury or assault on his father. And many of them are not eyewitnesses. See paragraph 35. 34, these are not eyewitnesses. 35, the injured said they did not say who attacked them. And Rafiqul Islam, son of the disease Akabbar, as per his evidence, he is the eyewitness to the incident, but it has not come in his evidence how he reacted to a situation when his father, Akabbar Ali, was allegedly assaulted by the accused person. His evidence suffers from police contradiction. Third, Mr. N. Uddin, learned counsel for the appellant, and Mr. K. Das, learned additional public prosecutor for the respondent. Number 1, State of Assam. The present criminal appeal under the proviso to Section 413 of the Bharatiya Nagorik Suraksha Samhita, 2023 is directed against a judgment and order dated 24/07/2024 passed by the Court of Learned Sessions Judge Borpeta in Sessions case number 03 of 2018. Full stop. In the trial of Sessions case number 03/2018, charges were framed under section 147, 148, 149, 342, 323, 325, 302, IPC, page 15 of us. And respondent number 2, respondent number 17, faced the chase charges in the trial, after trial, the learned Court of Sessions Borpeta, the trial court, has acquitted all the accused persons from those charges, full stop. Aggrieved thereby. You are an informant.
My lord, son of the deceased, my lord, victim.
The appellant has preferred this appeal, full stop. Para. We have perused the contents of the memorandum of appeal. Full stop. Para. Learned counsel for the appellant has submitted that your evidence was found deficient.
My lord,
The appellant is a son of one Akbar, AKKA, BAR, Ali. Full stop. According to appellant, the alleged incident, had occurred on 20/10/2011, and on the same date, the FIR was lodged, mentioning that in the incident, Akbar Ali sustained injuries on his person. Full stop. As per in a judgment under challenge, it has been recorded that Akbar Ali died in the Guwahati Medical College and Hospital after 15 days after the incident. Full stop. Para. The appellant has contended that the postmortem examination report of the deceased, Akbar Ali, neither the postmortem examination report of the deceased, Akbar Ali, nor the autopsy doctor was examined by the prosecution. Full stop. It is a contention that the prosecution has withheld some vital witnesses during the trial. Full stop. Issue notice returnable in 4 weeks. As Mr. Das, Learned Additional Public Prosecutor, has appeared and accepted notice for 1. Respondent number 1. Issuance of formal notice stands dispensed to the said respondent stands dispensed with extra copy of the memorandum of appeal. Learned the appellant shall take steps for service of notice upon the respondent number 2 to
17, madam.
17 by registered post with AD. Issue notice of পিছত আপুনি এটা কাম কৰিব records of sessions case number বিকল্প registered post with AD within 3 working days.
I'm present.
নোটিশটো নিলাম একদিন নগৰ এতিয়া এই যদি কয় ওকেখন গগল বুলি জডিশত মৰা বুলি যদি কয়
Supplementary list, item number 16.
হেৰা ইন্দোৰ এটা মানে কেন্দ্ৰিক দেখা আছে সেইকাৰণে আচলতে আমাৰ এডমিশ্যনতে যদি একো নাই তো ডিসমিস কৰি দিম এনেই এটা নম্বৰ পাই কি লাগিব আইটেম
16, Your Lordship.
16.
Nobody's present.
Item number 16.
DRA Sultana by order matter has come.
by order
Yes,
not available.
legal aid council.
We postpone it then. Admission matter. Learned Legal Aid Council. রাখি দেব আর ওর মাতি দিব after list to হেৰি হোৱাৰ পিছত এই এডমিশনৰ অৰ্ডাৰ হোৱাৰ পিছত হিয়াৰিং আৰম্ভ হোৱাৰ আগতে
Item number 2 for orders.
May it please, Your Lordship. My lord, in this case, I was conducting as legal aid counsel, but subsequently appellant has engaged my friend without intimating me. So I may be released, my lord, he will conduct it.
You submitted an application also. We'll observe.
Application
You
before-
submitted an application before registry.
My lord.
Mr. K.M. Haloy, Learned Legal Aid Council for the appellant and MS B. Bhuiya, Learned Senior Counsel and Additional Public Prosecutor for the respondent state are present. First up, Mr. U. Choudhury, Learned Counsel, has submitted that he has entered in the meantime, he has entered appearance on behalf of the appellant. First up, Mr. Haloy, Learned Legal Aid Counsel, has submitted that since the appellant has engaged a counsel, learned counsel, a set of learned counsel to represent him in this appeal, he will file an application before the registry for withdrawal of his name. First up. In as a set of learned counsel has been engaged by the appellant in this appeal, the registry on submission of an application for withdrawal by Mr. K.M. Haloy, Learned Legal Aid Counsel, shall delete his name from the area of counsel in the appeal as well as in the call list.
Mad.
Mr. Haloy has submitted that such an application will be filed within a period of 1 week from today. Full stop. Yes. Paper ready. Yes.
You've received.
What do you intend? You want to press?
Lordship, can the matter be taken up after 2 weeks, Lordship? We will
2
be
weeks.
pressing after 2 weeks. Because
After
we have
2
been-
weeks.
That's my lord.
Okay. As sought by, as prayed by Mr. Chaudhary, learned counsel for the appellant, list the application, list the case along with the I after 2 weeks.
I'm obliged, Lordship.
Item number 3,
Service is complete, my lord. Nobody has entered appearance. POXO matter.
One query of
Nobody-
Unserved notice. Madam Muya, what is offense?
I don't have the name.
302. Notice is not served upon the respondent number 2. It appears. We dispense with what to do. Village not known. It has come back with remark, a village not known. I think 302. Report 9, no? Report of service 9 again. Process server. And, MS
M. Kakuti.
M.
On
Kakoti,
behalf-
learned counsel representing Mr. R. Sharma, learned amicus curiae. For the appellant, and MS B. Bhuyan, learned senior counsel and additional public prosecutor. For the respondent state, comma, assisted by MSM Chakraborty, learned counsel are present. Also, the case records of sessions is number 31. Stroke 2017. Within bracket new. Stroke sessions case number 37. Of 2014. Old. Have been received. Also. The office to take steps for preparation of the paper. Release the case after 4 weeks.
item number 6,
Heard Mr. A. Kolita, learned counsel for the learned amicus curiae for the accused appellant and MS B. Bhuyan, learned additional learned senior counsel and additional public prosecutor for the respondent of 1, comma, state of Assam, assisted by MS M. Chakraborty. As per office note dated Lagon Lagongor, okay. As per office note dated 7/9/2024, comma, the AD card has been duly received after service of the notice upon the respondent number 2. Which his signature on the AD card. First of all. In view of the same, comma, the service of notice upon the respondent number 2 is treated to be complete. First of. As the case records from the trial court have been received, office to take steps for preparation of the paper book. List the case after 4 weeks.
Item 7,
MH law score. Learned amicus curiae for the appellant and B. Puya. A report has been received from the office of the civil judge, Junior Division Margarita, report dated 02/09/2020. First off, a report dated 2/9/2024 from the Seristadar Civil Judge Junior Division Margarita has been appended to the said report, wherein it is mentioned that the process server, the notice has been duly served upon the respondent number 2 by the concerned process server. First off, in view of such report, service of notice upon the respondent number 2 is treated to be complete. First off, but as the case records from the learned trial court have been received, office to take steps for preparation of the paper book. List the case after 4 weeks.
item number 8,
Same council, no share.
Hmm?
VRA Sultana, who is in item number 16 also. It's bound to be.
Learned legal aid counsel for the appellant is found absent today on call. Post of MS B. Bhuyan and senior counsel and additional public prosecutor for the respondent number 1, State of Assam, assisted by MS M. Chakraborty, learned counsel, is present. Post of. A report has been received from the office of the Chief Judicial Magistrate, Tinsukia. Full stop. 2/9/2024. As per the said report, in the said report, a report of the process server dated 2/9/2024 has been is appended, is annexed. First of, as per the said, as per the report of the process server, the notice upon the respondent number 2 has been duly served. First of, in view of such report, service of notice upon the respondent number 2 is treated to be complete. First of, as the case records from the learned trial court have been received, office to take steps for preparation of the paper book. List the case after 4 weeks.
item 9,
My lord, in this case, I was supposed to take a step in the IA, my lord, but I could not take in time. I may be allowed.
To notice.
So
Yes.
I'll take a step by today, my lord. In fact. Actually, I thought the steps were
Mr.
taken by
Payeng,
the-
heard Mr. Payeng, learned counsel for the, Mr. Payeng, learned counsel for the applicant has submitted that due to inadvertence, required steps for service of notice upon the opposite party number 2 in reference to the order dated 20/05/2024, could not be taken. Full stop. He has, Mr. Payeng has prayed for 2 days time to take requisite steps for service of notice upon the opposite party number 2 in deference to the order dated 20/05/2024 is full stop. The prayer Miss B. Bhuiya লিখি দিব আছে দুইজন লিখি দিব প্ৰথমতে Payeng লিখি
File
দিব
an
আৰু
objection.
Huh?
You've already filed.
They have already filed.
মিস ভূঞা প্ৰথমতে লিখি দিব হাৰ্ট লিখি দিব হা প্ৰথমতে একদম প্ৰথমতে লিখি দিব হাৰ্ট Miss Bhuiya has submitted that the state has already filed a written objection to the instant application. First of raise the case after 4 weeks for service report upon the opposite party number 2.
Item number 10.
May I please, Your Lordship? Not in this case, my lord, the informant already died, my lord.
Huh?
As per last Lozima court order dated 31/8, my lord. Lozima court order
Lower limit
in the main appeal, my lord. Order is
in the main appeal. Yes, informant expired 302.
Now connected criminal appeal is there, my lord. In that case, my lord, paper book is already ready, my lord.
Paper book can be ready. That is true. But records are not received yet.
In another case, it was received and paper book ready, my lord. Connected appeal, my lord, connected criminal appeal, 7/0/24, my lord. Matter may be tagged along with that matter, my lord.
Heard Mr.
Yes, sir.
Richard Ahmed, learned counsel for the appellants. And Mr. K.K. Das, learned counsel for the respondent number 1, State of Assam. Post of. As per the report dated, as per the order dated 31/8/2024 of the Loajima Court, the respondent number 2 has expired several years ago. First of para Mr. Amit, learned counsel, as per office note dated 9/9/2024 comma, the case records from the learned trial court are yet to be received. Full stop. Para, Mr. Ahmed, learned counsel for the appellants, has submitted that the case records from the trial court records have already been received in connection with another criminal appeal, comma, criminal appeal number
74/24.
74 of 2024, comma, which arises out of the judgment dated judgment passed by the learned additional session judge Bilasipara in sessions case number 66 of 2016. Full stop. In view of here and full stop, Mr. Ahmed has submitted that this appeal be also listed along with criminal appeal number so and so. Full stop. The submission of the counsel for the appellants is also endorsed by Mr. Das, learned additional public prosecutor for the respondent state. Full stop. List this appeal along with so and so criminal appeal after 3 weeks.
Obliged.
Item 11,
এই কন্ডোনেশন এটা আছে না কন্ডোনেশন না
May I please-
অর্ডারটা ছিল না
May it please, your
Yes.
lordship. My lords, along with appeal, your lordship, we have filed the petition for condition of delay, your lordship.
offense is what 302
Please, your appeal, lordship. 156 days delay, your lordship. In filing the
video it we করে দিও Heard. Yes, Mr. Das. Heard, Mr. A. Diwan. Learned counsel for the applicant, appellant. And Mr. K. Das, learned additional public prosecutor for the opposite party number 1, state of Assam. Full stop. The instant interlocutory application. এটা আছে হ্যাঁ আছে এটা কিমানৰ কৈ থাকিব খালি লিখিব how many days delay
156 days delay, your lordship.
okay চাই ল'ব prefer the accompanying criminal appeal against the judgment and order dated huh 2012 179 days এইটো কাহি কৰি
Oh, 117, lordship, I'm sorry, lordship.
2012 2023 huh
170, ठीक for a minute.
कोर्ट ऑफ learned session judge हो जाए sessions case number
Questions.
session within bracket 1 number to silo web dictation di taka dikai এনেকুৱা কিবা নম্বৰ দিছে চাই ল'ব এইটো এটা so and so by the judgment and order so and so 302 302
302, lordship.
302 absolutely rigorous imprisonment
For life.
for life and to pay a fine of rupees 10,000 in default 6 months. The applicant appellant is presently in jail serving the aforementioned sentence, huh? Full stop. Mr. Das, learned additional public prosecutor, has fairly submitted that he has not received any instruction to oppose the instant application seeking condonation or delay. Full stop. Mr. Das has further submitted that state will have no objection if the accompanying criminal appeal is heard on merits. Full stop. Para. On perusal of the application, we find that the period of delay which has occurred for filing the accompanying criminal appeal is 179 days beyond the statutory period of limitation. Full stop. We have perused the statements and averments made in the instant application, more particularly, paragraph 9 and 10 thereof, wherein the applicant appellant has explained the reasons for the delay. Full stop. Paragraph 6 to লিখি দিব। Paragraph 6 to লিখি দিব। তাৰপিছত 7 to লিখি দিব। দি দিব। এটাই দি দিব। Allowed.
No, not so like this.
Item number 12.
This is an application under 415(2) of DNS minor. This is an application under 415(2) of DNS minor against judgment and order dated to 27/24 minor, passed by the learned session judge Dibrugarh under section 302 minor, convicting the person under section 302.
The criminal appeal is not yet admitted.
Yes,
Let it be admitted first.
yes, madam.
The appeal,
Yes.
it should have come in the admission column actually.
Yes, yes, madam.
Heard Mr. D. Bora, criminal appeal to likhibo, huh? How many appellants?
There are two appellants, madam. No, no, right now, we are for one appellant.
Learned counsel for the accused appellant.
One appellant.
And Mr. Kekeras, learned additional public prosecutor for the respondent number 1, State of Assam. This criminal appeal under section 415
For one.
within bracket 2 of the Bharatiya Nagorik Suraksha Sanhita, 2023 is directed against a judgment and order dated
27.
20/07/2024 passed by the Court of Learned Sessions Judge Dibrugarh in Sessions case number 162 of 2014. Full stop. By the judgment and order dated 20/07/2024. Two accused persons, including the present accused appellant, have been convicted for the offense No, Mr. Bora,
Yes, my lord.
You are the only one.
Yes,
Ah,
I'm
then,
applying for one appellant.
ah,
Yes.
you are the only one convicted. You have not read the brief perhaps. Please come to page
Sorry, my lord.
50. Page 50,
Yes.
paragraph 57.
Yes, ma'am. Sorry,
First read the brief, then you make submission.
my lord.
By the judgment in so and so, the accused appellant has been convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 4 months. We have perused the contents of the memorandum of appeal. Post of the criminal appeal is admitted for hearing. The records of sessions case number so and so be called for. Issue notice returnable in 4 weeks. As Mr. Das, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam, issuance of formal notice to the respondent number 1 stands dispensed with. Post of extra copy at the Divokova 3 working days. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 working days.
There's an I, my lord. Yes, my lord.
Well, after LCA, I'll list the case after 4 weeks. Issue notice returnable 4 weeks. Please.
Supplementary list, item number 17.
The notice is sent recently only, Lordship.
Huh?
Notice is sent recently only, Lordship.
Lala.
And-
You are MS Lala.
Lordship may direct the registry to prepare the paper book as Lordship, the petitioner has been under conviction for more than 10 years, Lordship.
No
Or
state.
10
How do you miss this? Huh? Or wrong. Bad program. LC আহিলে নাই পনেরোশো আছে চাওঁ কিমান দিনৰ It is in your own fault, madam. You are lying in detention for 10 years because a period of 2,307 days has been condoned. It is your fault. It is not the court's fault that you are lying in jail for 10 years. You have preferred the appeal after 2,307 days. That has been condoned. What is the offense?
Section
302. Now, objection has been filed by the state already in the IA. Today is for consideration of this IA.
My senior is in Lex, Lordship.
It goes in not to us. I don't know, 10/9/2024. What goes it? From north to south, No, please not, please not. Itu tak bisa ni. Itu naik ni. Itu naik ni. Appeal tu. Itu appeal tu. Appeal tu. Itu. Appeal of Trico. Third MS Ilala, Learned Counsel for the Appellant, and Mr. K. Das, Learned Additional Public Prosecutor for the Respond number 1, State of Assam. Full stop. In view of the office note dated 10/9/2024, await for the service report in respect of the Respond number 2. Full stop. As the case records from the trial court have been received, office to take steps for preparation of the paperwork, release the appeal release the case after 4 weeks. Full stop. I, Lala, applicant appellant, K.K. Das, additional public prosecutor for the opposite party number 1, State of Assam. Full stop. The objection by the state has been filed and is in the record. Full stop. As sought for by MS Lala, Learned Counsel for the applicant appellant, release the case after 4 weeks.
Item number 16,
9. Yes, Mr. Das. Tell us. I order some. I do. Oh, I ready for you. 2000 kiman, 1000 kiman, 2000. Imagine deliver the Hadina. I will delay over me. Huh? This interested not easy to take it. We will consider interesting. The Learned Legal Aid Council is found absent even today, even after second call. Mr. K.K. Das, Learned Additional Public Prosecutor for the respondent number 1. Number 1, for the false title. Okay. For the respondent number 1, State of Assam is present. Full stop. On this criminal appeal from jail is preferred against the judgment, an order dated 25/05/2016, passed by the Court of Learned Session Judge Jorhat in Sessions case number 169 within bracket J-J of 2024. Full stop. By the judgment, an order dated 25/5/2016, the accused appellant has been convicted for the offense of murder under section 302 Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. So we have perused the contents of the memorandum of appeal. First of the criminal appeal is admitted for hearing. The case records of sessions case number so-and-so be called for issue notice returnable in 4 weeks. as Mr. Das, huh? Appeared accepted. লিখি দিব আগৰটোৰ নিচিনা আৰু similarly shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 working days. হৈ গ'ল নেকি চব?
Third matter for hearing, item number 18.
পক্সো দিয়ক পক্সো দিয়ক হা নালাগে এইটো হৈ গ'ল কালিয়ে আৰু বেলেগ নাই yes anything
Lordship, may I kindly see page 41, the sentencing part first, Lordship.
page
41. May I read?
hmm
The accused Rajesh Patnaik produced in the court, learned special PP and learned counsel for the accused present, heard both sides on the point of sentence. Statement of the accused is recorded in a separate sheet and enclosed to the case record. The accused stated that he has nobody in his house and he is to entertain the people in the marriage ceremony and gets 5,000 per month in average manner. The accused is fairly a young person. So Lordship, may kindly note that fairly a young person. There is no proof of previous conviction. Second mitigating circumstance, but he has committed a very serious crime against an innocent child who has in no way enmity against him. Such offense cannot be allowed to increase in the society as a whole. Therefore, the accused is
whatever we have heard
Till PW five.
it has gone out of my mind,
Yes, my lord.
right? I cannot retain.
Yes, it was, my lord, here the husband was accused of killing the wife, my lord.
Okay, we will hear you.
Yes, my lord.
But what is the judgment?
Page 77 it starts, my lord.
Two 2010 or incident. 2016. 2007, 7 years like this. What is the sentencing part?
Page 99, my lord. Para 39.
Yes. Yes. Where is the FIR?
The page 4 is the FIR. FIR lodged by PW1, my lord.
Page 4. Visual record count.
The page 7 is the committal order, my lord.
Page
7 is the committal order, my lord. Initially, the accused absconded, my lord. Then he surrendered on 26/11/2010, my lord.
used. Surrendered.
On 26/11/2010, my lord.
G6 11.
Yes, my lord.
Okay. Charge order
Page 6, my lord. T0 to
or
30.
commitment order.
Commitment order is page 7, my lord.
My Bora has appeared in the court, filed a petition for a line. Petition law is produced from Delhi. Yes. The charge.
Page 6, my lord. Charge was two persons faced the trial, my lord, mother and the appellant, my lord. Appellant's mother and his appellant, my lord. 30 to 34, my lord. The appellant has been convicted under 30 to simplicity, my lord.
Yes.
The appellant's mother was acquitted, my lord. Page
Mother has been acquitted on benefit of doubt.
same set of evidence, benefit dot, my lord. 34 was there, my lord. Page 8 is PW1, my lord. The informant, father of the victim, my lord.
Informant.
Father of the victim, my lord. Yes, my lord.
Father of deceased.
The deceased, my lord. May I read, my lord?
What is the name of the deceased?
Her name is in the FIR, my lord. It is Bijoy Lakshmi Hazarika, my lord.
Bijoy. Bijoy. Lakshmi. Yes.
At present, I'm serving as a teacher in Gopal Bora LP School in Tekela Borua village. Vijay Lakshmi Hazarika was my daughter. We married off her to Bharat Bora as per Hindu rites and rituals on 2nd of June 2010. After her marriage, my daughter continued to do her job as a computer assistant, which she had been doing before her marriage. My daughter often used to talk to me over the phone. On 9th of August 2010, she told me over phone at night that her husband had kicked her that day. She further told me
Yeah.
that her mother-in-law Khudmai Bora was rebuking.
One minute. Yes, on 9th of August.
On 9th of August 2010, she told me over phone at night that her husband had kicked her that day. Occurrence is 14th of August, ma'am. She
Hmm.
further told me that her mother-in-law, Khudmai Bora, was rebuking her that night, alleging that she did not do the daily chores. My son-in-law and his mother are present in the dock today. My daughter has been doing job as a computer assistant at Dergaon, Soital Mara. At 8:30 p.m. on 13th August 2010, she informed me that she got the contractual job of science teacher in Jorhat Tekelagaon school and that she would have to join the post on 14th.
Where the accused are residents?
They are in Jorhat, my lord. The informant is from
Mura, Komargaon, Jorhat.
Jorhat, my lord, and the informant is from Golaghat, my lord.
Informant is from Golaghat.
Golaghat.
Okay, just see further told me. You just start from there again. 7th line. See further told me. 6th line, 7th line. Second word. 7th line.
Page 9, my lord.
Page 8 only.
Page 8. my lord.
You go slow, bit slow.
She further told me that her mother-in-law, Khudmai Bora, was rebuking her that night, alleging that she did not do the daily chores. My son-in-law and his mother are present in a dock today. My daughter had been doing job as computer assistant at Dergaon Soital Mara. At 8:30 p.m. on 13 August 2010, she informed me that she got the contractual job of science teacher in Jorhat Tekelagaon school and that she would have to join the post on 14th August. She also asked me how to write the joining report and accordingly, I told her how to write the same. In the night of 13 August, I had a talk with her over mobile phone, but at 5:30 a.m. on 14th August, my son-in-law's cousin, daughter of his father's elder brother, informed me that my daughter had suffered burns on her face by the fire of gas stove while she was making tea. When I asked her as to whether my daughter had been taken to hospital or not,
His cousin has been examined. My son-in-law's cousin,
she is, my lord.
is she examined?
One cousin has been examined, my lord. Monju Sokia, page 31, PW 11.
She has deposed that she informed.
She has deposed that on the date of incident, her cousin, Shri Raju Bora, informed over telephone.
No. Who informed the lady who informed the informant? Was she examined?
No, the informant has said a lady informed, my lord.
Daughter of his father's elder brother.
Yes, and the accused sister who has been examined, my lord, PW 11, she says that one cousin, Raju Bora, informed the informant.
Okay.
I asked her to call a 108 ambulance and take her to hospital. In the meantime, arranging a vehicle, as I, accompanied by my wife, was coming to the house of my son-in-law, I got the information that my daughter had been taken to Jorhat Civil Hospital. Hence, my wife and I went to Jorhat Civil Hospital. We reached the civil hospital 7:45 a.m. and saw the dead body of my daughter there. I did not notice any specific burn on her face, but I noticed a black mark measuring about 1 inch in width on her neck. I saw a little ash on her neck and nose. I noticed that a few strands of her hair above the forehead got burned and that her tongue had protruded from mouth. I also saw vermilion on her forehead and her face was normal. Suspecting a foul play, I lodged an ejahar with the PS. When I went to the hospital, my son-in-law was present there. Entering inside the campus of the hospital, I came across Robin Kolita. Robin Kolita is PW12 man, who works in the police department. I told him that I suspected foul play in this incident. Thereafter, I went to lodge an ejahar. On my return, I did not find my son-in-law there. Exhibit 1 is the said ejahar. I got the ejaha written by Kamal Chandra Gogoi. Exhibit 1 is my signature therein. One magistrate held inquest on the dead body of my daughter. Exhibit 2 is a said inquest report. At that time, the investigating officer was also present there. Thereafter, the dead body was taken for post-mortem examination. Then my son-in-law was absconding. After the PM examination, the cousins of her husband took the dead body away. Niren Kakoti went to the hospital along with me. In cross-part mirror. The marriage between my daughter and the accused was solemnized with the consent of the families. The age of the mother of my son-in-law is about 65 to 70 years. I do not know if the mother-in-law of daughter suffers from any ailment. After her marriage, my daughter occasionally paid visit to my house on Saturdays. My daughter did not intimate about any other disputes with her husband except for the one that occurred on 9th August. I have not mentioned in the ejahar about the phone call made on 9th August. I lodged the ejahar on 14th August. Police interrogated me immediately after I lodged the ejahar. It is not a fact that on 9th August, my daughter did not phone me and inform me that her husband had kicked her and that her mother-in-law Kudmai Bora had rebuked her, alleging that she had not done the daily chores. It is not a fact that I did not receive any phone call on 9th August. I learned from other people that my son-in-law had taken my daughter-in-law to the hospital and I met my son-in-law in the hospital. Sometimes my son-in-law used to drop my daughter in her office by taking her on vehicle. It is not a fact that I stated before the police that her neck had got severely burnt. It is not a fact that I stated to police that I had noticed burns in the forehead, face, left hand, and on the right side below the chest of Bijoy Lakshmi, and that I also found her hair burnt. It is not a fact that I did not state that I had noticed black mark on the neck of my daughter. From the cross, it can be seen that the relationship with the husband and the wife was very much cordial. Further cross, my lord. My son-in-law told me that he worked as a teacher in a school. Police took my statement in Jorhat Medical College outpost while my daughter was in the hospital. Well, as per PW1, his statement was taken on the date of lodging of the FIR, my lord. That is date. Police took my statement in Jorhat Medical College outpost while my daughter was in the hospital. So on the date of the lodging of the FIR, according to him, the police took his statement, my lord. That is on 14/10, my lord. Oh, sorry, my lord. That is 14/8, man. But his 161 was recorded on 25/8/2010, man. 25/8/2010, man.
Yes.
Some 4-5 days after that, the in charge of Raudia outpost interrogated me in Jorhat Sadar PS. It is not a fact that I had been interrogated for the first time before I lodged the ejahar. The incident took place about after 70 days of the marriage. My daughter visited my house several times after the marriage. After the marriage, my daughter occasionally spent nights in her house about 7 times. During that time, she did not raise any serious allegation against her husband. It is true that I did not mention in the ejahar about my daughters talking to me over phone. I did not mention in the ejahar about her mother-in-law abusing her, alleging that she had not done the daily chores. I did not mention either in the Ejahar or before the police about the phone number through which my daughter had made phone call to me on 9/8/2010. My daughter had been doing her job till 13/8/2010. On 13/8/2010, she did not raise any allegation against her husband over phone. I lodged the Ejahar against the accused persons, suspecting them to have murdered my daughter. While interrogating me, the in-charge Raudia outpost did not ask me as to why I suspected the accused person, nor did I tell him about that. I did not state to police about seeing of a black mark measuring about 1 inch in width on the neck of my daughter when I had first seen her in the hospital, as I did not mind it then. Going to the hospital, at first I did not mind as to which parts my daughter's body had suffered burns, but at that time of inquest, I noticed the mark in the neck and the burns on the body. It is not a fact that my suspicion is baseless. Well, PW2 is the neighbor of PW1, my lord. He went along with PW1 to the hospital, my lord.
Neighbor of?
Page 12, my lord.
Neighbor of?
PW1, my lord. They both went to the hospital together, my lord. I know Suresh Hazorikar, PW1. His house is near that of mine. I knew his daughter. Around 5 a.m. on 14/8/2010, I was at home when Suresh Hazorika informed me that something had happened to Mina. He, along with his family members, went to inquire about the matter. Later, he called me to the medical. I reached the medical at 8 a.m. and saw the dead body of Suresh's daughter Mina in the hospital. After a short while, police arrived there. A magistrate also arrived there. When I had a look on the dead body, I noticed a black mark in the neck arising out of pressing of the neck, and that her tongue had protruded a little. I saw minor burns in her cheek and forehead. Her hair did not get burnt. I saw vermilion on her forehead. Police came there. At first, I found the accused present there before the arrival of the police. But later,
Yeah, right.
I did not find him there. Exhibit 2 is the inquest report prepared in my presence. Exhibit 2.2 is my signature there. Cross part, my lord. It is not a fact that when police came, the accused was present there. It is not a fact that I did not state to the police that I noticed a mark in the neck arising out of pressing of the neck of the girl. I stated to the police that injury marks were present on the face, neck, chest, and head of Mina. It is not a fact that I have falsely stated that I noticed a black mark in the neck arising out of pressing of the neck. Well, PW3 is a cousin of the accused person, madam. And he has been declared hostile, madam. I know the accused persons present at the dock. The accused Bharat Bora is my cousin brother. And accused Khudmai Bora is my aunt. After 1 year ago, the occurrence happened. In that incident, the wife of the accused Bharat died. My house is adjacent to accused Bharat's house. The marriage between the deceased and the accused Bharat was solemnized 2 months prior to the death as per Hindu rites and rituals. There was no quarrel between the married couple, and there was cordial relationship between the accused and the deceased. On the date of occurrence, I was at my own house, and at that moment, at about 5:30 a.m., hearing noise from the house of the accused, I immediately rushed to the house of the accused. I noticed that accused Bharat's wife was lying in a burnt condition in which the kitchen and gas stove was also burning at that time. I switched off the regulator. Somebody called 108 ambulance, and the accused Bharat, along with some other persons, brought his wife to the hospital. Later on, police seized the gas stove cylinder pipe with regulator via Exhibit 3. Declared hostile manner and crossed by the prosecution. Police recorded my statement under section 161 CRPC.
1 minute. Yes, cross by prosecution.
Yes, my lord. He has
Hmm.
resigned from his statement, my lord. He has not admitted to this same, my lord. It is not a fact that during my 161 statement, I stated that since after the marriage, Bharat Bora and his mother often abused the girl.
Where from you're reading? What minute?
Page 14, last paragraph.
1 minute. I have not read that. Yes.
It is not a fact that during my 161 statement, I stated that since after the marriage, Bharat Bora and his mother often abused the girl. Around 14/8/2010, at about 5 a.m., I heard scream of Bharat's wife, stating they kill me, they burn me. It is not a fact that I stated before police that this murder incident was pre-planned, and I suspected that it was done by accused Bharat and his wife, as because at the time of incident there were only Bharat and his mother and his wife at their house. And over and above this, I also noticed one black mark like that of strangulating by cloth in the victim's neck. Bharat's father-in-law's house is at Dergaon. I did not notice Bharat's father-in-law at the place of occurrence while I visited the house of Bharat. The gas stove was lying on the table and it was burning over the table. The victim was lying on the floor. The small burner of the stove was burning at that time. The victim was lying at about 5-6 feet distance from the gas stove. There was some water lying on the floor. The water was lying prior to my arrival at the PO. I did not notice properly on which part of the body there was burn injury on the victim. One of my uncles resides at the opposite side of the accused family, and they had no quarrel with the accused. They had visiting terms with the accused family. I heard that the deceased got a job of science teacher. I got the said news from the accused Bharat and also from some neighboring person. I did not visit the house of the accused father-in-law. I did not meet the father of the deceased after the occurrence. I heard the family of the deceased came to the place of occurrence later on. My house is at a distance of 10 meters from the house of the accused. I only noticed accused Bharat in his house while I visited his house immediately after the occurrence, and thereafter for 3-4 months, I did not meet accused Bharat. The deceased was cremated in the land of accused, but at that time of cremation, accused Bharat was not present. I met accused Bharat after his return from jail. I visited his house after their return from jail. It is not a fact that as the accused persons are my close relative, I, concealing the actual fact, deposed falsely. I did not collect any information about how the victim died. Crossed by defense. At the time of death, the deceased did a job and she got a new job. Accused Bharat at the time of occurrence was also performing job at school and did tuition also. At present also he works at a school. Accused had visiting terms with his father-in-law's house, and family member of the house used to visit the house of the accused. The deceased used to visit our house, and she also visited some of the houses of the neighbor. She never gave any complaint to us against the accused person. I could know that deceased got the burn injury from the gas stove. The deceased was not in a talking condition while I visited their house, and she was completely burnt at that time. I have no knowledge wherefrom police arrested accused Bharat. I could know that on the date of occurrence, accused Bharat was arrested by the police. I have no knowledge whether due to his arrest, accused Bharat could not appear at the time of cremation. While I visited the house of the accused at that time, accused Bharat and his mother were crying for help from the neighbors. It is not a fact that I have deposed concealing some material facts. PW4 is again a cousin of the accused person, my lord, accused appellant. Page 17, my lord. I know the accused persons present at the dock. One of the accused is my aunt, and other is my cousin brother. My house is situated at a distance of 25 feet from the house of the accused. The accused performed marriage with the deceased about 2 months prior to the death.
He is also neighbor
He's a cousin, my lord.
and neighbor also.
Neighbor and cousin, yes, my lord.
Neighbor and cousin, both neighbor and cousin. The accused performed marriage.
The
Third line.
performed marriage with the deceased about 2 months prior to the death. The occurrence happened in the month of July 2010. One day morning, hearing noise from the house of the accused, I came there and found that in the kitchen the deceased was lying and her head was on the lap of my mother. Well, his mother is PW5, my lord.
Oh,
My mother arrived at the place of occurrence prior to my appearance. I noticed burn injury on the head, neck, portion of hand, and on the cheek of the deceased. And her wearing blouse was slightly burnt and torn, and other wearing clothes were quite okay. Some people gathered there informed me that she got burn injury from the gas stove. While I visited the house of the accused, I noticed Bharat Bora was busy talking with somebody over telephone. I called 108 ambulance by my phone, and at that time Bharat Bora came near to his burnt wife. While I inquired Bharat what had happened, he informed me that his wife was burnt by a gas stove. I also went to the hospital, and accused Bharat Bora also accompanied me to the hospital. While Bharat's wife was brought to the hospital, doctor informed that she was already expired. The doctor informed that postmortem have to be done and advised us to inform police. After her arrival, sometime later, the family member of the deceased appeared at the hospital. Police came and executive magistrate were also appeared. At that time, father-in-law of the accused Bharat was present. While inquest was prepared on the dead body, we were present and I put my signature. Exhibit 2 is the inquest, 2-1 is my signature. Raju Bora appeared at the place of occurrence after my arrival. Raju Bora is PW3, my lord. While I prepared at the place of occurrence, at that time the gas stove was switched off. The deceased was lying on the floor at a distance
switched
of
off.
switched off. My lord. Raju Bora says that he came and switched off the gas stove, my lord.
So
But PW4 says that
they are not saying the truth.
PW4 says that Raju Bora came after him, my lord.
Yes.
The deceased was lying on the floor at a distance of 4.5 to 5 feet away from the gas stove. I do not know who switched off the gas stove prior to my arrival. Accused Bharat was not present while police and magistrate appeared at the hospital and inquest was done on a dead body. I have no knowledge where Bharat went at the time. I took Zimma of the dead body after postmortem. While the dead body was cremated, accused Bharat was not present at the time of cremation. My statement was recorded by magistrate. Exhibit 4 is the said statement. 4-1, 4-2, 4-3 are my signature. Police also took some photograph of the dead body and place of occurrence, and said photograph was seized by police by journalist.
Let us see his statement. Page.
Whose statement, my lord?
Exhibit. Statement. Exhibit 4.
My lord.
Page.
109, my lord. Which you will see, my lord.
Okay. Cross.
Page 18, madam.
Hmm.
I did not hear any quarrel between the accused and the deceased. While I visited the place of occurrence, my aunt, the another accused, was lying on the bed as she was suffering from blood pressure. Accused Bharat accompanied the deceased while she was brought to the hospital, and he was present at the hospital till I went to the police station. He talked with doctors regarding her treatment. The deceased was not in a talking condition while she was brought to the hospital. I heard at the place of occurrence that she was burned by fire of the gas stove. The doctor could not treat her at the hospital, and prior to providing any treatment, she expired. Probably accused Bharat informed the father-in-law about the incident. My mother came earlier to me to the place of occurrence. I have no knowledge when Raju Bora came to the place of occurrence. The deceased did not complain me or neighbors about any ill treatment by the accused. The PW5 is the mother of PW4, man. Also a neighbor, man. I know the accused persons present at the dock. Their names are Shri Bharat Bora and Khudmai Bora. Bharat Bora, the son of Khudmai Bora. About 1.5
He is
years.
also relation then.
Yes, yes, Milo. 4 is the cousin of the appellant, Milo. So 5 will be the aunt, Milo.
Definitely.
I heard noise in the house of the accused at about 5 a.m. The house of both the accused person is situated adjacent to our house. I myself.
All three are, this is Raju, Rakesh, and Thunumai. Thunumai is the mother of PW3 and PW4. Father,
Samuna
their
Bora, yes.
father is Sambhu Nath, and husband name is of PW5 is Sambhu.
Shambhu Bora.
And PW5 says that my son Raju Bora.
I and my son Raju Bora went to the house, yes, Milo.
Is another son.
I myself and my son Raju Bora went to the house of the accused persons. I saw the wife of the accused lying at the kitchen at the house of the accused, and her clothes were burning at that time. While I went to the house of the accused persons, I met both the accused inside the house. The clothes of the wife of the accused, Bharat, were burning. Accused Bharat Bora was crying, holding his wife's hand. While I was present at the house of the accused,
Wife's hand. Accused is crying, but at the same time, her clothes are burning. He is not trying to douse the fire.
PW. Yes, madam.
She was the first to arrive. She said, I met both the accused inside the house. They were there. The hairs and clothes of the wife of accused Bharat were burning.
Were burning.
Burning. Joli ase.
What kind of burning we do not know.
Yes. What kind of burning? We don't know. Burning is burning.
Burning is, that is the thing, madam.
Hairs and clothes. There is no double meaning. Hairs and clothes of the wife of the accused Bharat were burning.
My lord.
Accused Bharat was crying, holding the wife's hand. He is holding the wife's hand and crying, but not trying to douse the fire. From it looks like he was not trying to douse the fire.
My lord. But PW.
She came.
3 then says that
But Raju said
something else. madam.
something else. Usually for saying something else.
Slightly burning and torn. Her clothes were slightly burned.
Who?
PW4.
Okay.
PW4.
So he came after
He came after
his
that.
mother. And he does not know when Raju came. But Raju came later on, according to him.
According.
But Raju says
He was the first person there.
he was the first.
Yes, we saw the regulator.
And perhaps mother was not declared hostile. Not hostile.
Not hostile.
Crying, but holding wife's hand. Well, I was present at the house of the so-and-so. Okay.
Well, I was present in the house of the accused person at that time.
And interestingly, Kudmai Bora's blood pressure is so high that her daughter-in-law was burning, but she was sleeping on a bed.
Yes, ma'am.
Interesting.
In the cross, my lord.
Blood pressure is high, but it's not saving a person from burning.
In the cross, my lord, the PW5 says that.
We have not reached that
Yes,
cross.
yes.
We may change our view.
I'm
We
just
may
saying,
change our view, but whatever is there, so that we can also understand.
5 says that her appellant's hand was broken. Then holding,
Appellant hand was broken.
Hand was broken.
Any proof?
no, madam,
No proof.
nothing exhibited.
Huh? Whose hand was broken?
The appellant's hand was broken, madam.
Appellant.
Yes, madam.
Where is that?
It is in the cross, madam.
Okay, we'll come to that. But we are trying to find out this interplay of PW3, PW4, and PW5.
Madam, 2 says that,
Mother and two
the
sons.
2 says that he went first. He saw her on the floor. He switched off the gas. 4 says that he went after everybody else, my lord. The mother was there. The deceased head was on the mother's lap. And then he does not know when 3 came. 5 says that 3 and 5 went together and then saw the appellant holding the hand of the deceased man. So all 3 are.
There was no apparent active part. No apparent active part
No.
on the part of the mother-in-law and the husband, except holding the hand and crying.
Holding the hand and
So far.
And my lord, the husband
Burning, but this daughter-in-law or wife was not talking.
was not talking.
Was not talking.
Not talking.
Was not talking at all. Burning, we have seen the extent of burning. But she was silent,
Yes, ma'am.
interestingly.
Because Lordship on last occasion, Lordship had seen, my lord, her death was actually due to asphyxia, my lord. And the burns were post-mortem, my lord.
That is what it is emerging, that PW 3, 4, and 5, it can be assumed that they have gone to the place, hardly their houses are 20-25 feet
Neighboring house.
distance. So in close proximity, they have appeared at the place of occurrence. And this mother was first
Mother was first.
to arrive. She saw
According
the
to
disease burning. But she was not speaking. And accused was crying, holding her hand.
Right.
And PW4 says mother-in-law was sleeping on a bed because of high blood pressure. And who switched off the PW3? But according to PW4,
he never saw.
PW3 came later on,
He does not know when he came, my lord.
but he doesn't know.
He does not know. But when he PW
And
came,
somebody said that disease was on the lap of his mother,
that is PW4, my lord.
PW4. And
PW4,
so this Raju Bora,
my lord.
mother says, me and Raju Bora went together.
Together, my lord. Raju
This
Bora-
Raju Bora has been declared hostile
Yes, my lord.
because he has deviated from his previous statement.
My lord.
Okay. Accused Bharat was crying.
My lord.
That part. Okay. Then we stop at this. You repeat from accused Bharat Bora
Was crying.
was crying. Then things will be refreshed. Yes.
Page 20, my lord.
Mhm.
Accused Bharat Bora was crying, holding his wife's hand, my lord. While I was present at the house of the accused persons at that time, many other persons, including the NGO personnel, came to that place. The wife of the accused Bharat Bora was immediately brought to the hospital, and later on I could know that she died at the hospital. I cannot say how the fire caught on the body of the deceased. While I visited the house of the accused persons, I found that the gas stove was in burning condition. The deceased had no issue. Cross, my lord. Our house is situated at some distance from the house of the accused persons. We had visiting terms with the accused. I sometimes also met the accused, the deceased. Relationship between the accused and the deceased was cordial. While I went to the house of the accused persons, at that time the gas stove was in burning condition. At the time of occurrence, the right hand of accused Bharat Bora was fractured due to some accident. There was plaster in his hand. The other accused was also in ailing condition at that time. PW6 is a neighbor, my lord. Page 22. ma'am. I know the accused persons present at the dock. Their names are Bharat Bora and Pudmai Bora. Pudmai Bora is the mother of Bharat Bora. I also knew the wife of accused Bharat Bora. Their house is adjacent to our house. In the house of the accused himself, his mother Pudmai Bora and wife of the accused Bharat Bora resided. At about 1.5 years ago, one day at about 7 a.m. in the morning, hearing the noise in the house of the accused persons, I could know that the wife of the accused Bharat Bora died due to burning. I could also know that she died in the hospital where she was brought after the burn injuries. I did not know anything about the occurrence. Page 23, again the neighbor, my lord. I know both the accused persons present at the dock. They are my neighbors. The occurrence happened about 1.5 years ago. During that period, I was in my house on leave. On the date of occurrence at about 6:37 a.m., I noticed one ambulance in front of the house of the accused persons. I noticed from a certain distance that one person was carried in the said ambulance from the house of the accused. I have no visiting terms with the accused persons. One of my aunt, who returned back from the place of occurrence, informed me that the wife of accused Bharat Bora got burn injuries on her face from the gas stove while she was preparing tea. My house is at a distance of about 20 knolls away from the house of the accused. I noticed accused Bharat Bora while the person from his house was carried in the ambulance, but thereafter I did not notice Bharat Bora after the incident in his house. I have seen the accused Bharat Bora accompanied the person in the ambulance. I have no knowledge what treatment was provided to the patient. PW8 is a hostile witness, my lord. I know the accused persons in the dock. They reside adjacent to my home. About 1.5 years ago, Bharat Bora's wife expired. On that day, I was present at my own house. On one morning, I came to know that one ambulance came to the house of the accused Bharat Bora, in which his wife was taken to the hospital. In the evening, I could know that the wife of accused Bharat Bora expired. The house of the accused is 30 meters away from my house. I declared hostile in cross-examination on behalf of the prosecution. I did not notice accused Bharat Bora in his house after the occurrence. Police recorded my statement under section 161 CRPC. It is not a fact that I stated before police that on 14/8/2010 at 5 a.m. I heard scream of some woman from the house of the accused Bharat Bora's kitchen. Immediately gathered near the house of accused Bharat Bora, and I also visited his house and noticed that Bharat's wife Vijay Lakshmi Bora was lying on the floor of the kitchen with burn injuries at her face from the gas stove. It is not a fact that I have stated before police that though the family members brought her to Jorhat Medical College and Hospital but could not save her, I had strong suspicion that Bharat Bora and his mother is behind the murder of Bharat's wife. It is not a fact that I stated before police that I heard that Bharat Bora was absconding. I have no visiting terms with the accused family. It is not a fact that I have stated falsely today to save the accused persons, concealing the real facts. On behalf of defense, my lord, whatever is deposed today by me is wholly true. The PW9, he was the one who took the photographs, my lord. Only that part. On 14/8/2010, in the morning, I was at my studio and police called me to JMCH for taking photograph of a dead body. Police showed me a dead body at JMCH and disclosed that the dead body of one Bijolakshi Bora.
Station court order shipping.
Dead body was found in burn condition at the backside of the deceased. I noticed some black marks in the neck and also found some portions of the hair of the deceased in burn condition. As per direction of police, I took photographs of different parts of the body. Material exhibits 1, 2, 3, 4 are the photographs taken by me over the dead body. Exhibited under objection. I have no knowledge about the occurrence. It is a fact that I did not state before police that I have witnessed burn injuries on the body of the deceased and that I noticed black marks on the neck and back of the backside of the dead body. That I noticed some portions of the hairs of the deceased were in burn condition.
No.
The original memory card in respect of the photograph is not furnished to the police. The PW10 is the ambulance driver, my lord. Page 29.
Hey, is it? Yes. Okay, like 15 years later, which is in 2002. That's question. Just a minute. Yes. PW?
PW10, my lord. He is the EMT, my lord. Page 29. I am a teacher of Junior College, Jorhat by profession. On 14/8/2010, I was working as emergency medical technician of JVK EMRI project based at Jorhat. On that day about 5:06 a.m., while I was on duty, we received a phone call from the 108 call center informing us that there was a burnt case at Pokamora, which was at a distance of 4 or 5 kilometers from Raudia police outpost. And we were directed to visit the place in order to bring the victim for treatment. We reached the place of occurrence and we found the victim, who was a lady. We brought her initially to Mission Hospital, Jorhat, where the doctors were absent. And thereafter, we brought the victim to Jorhat Medical College and Hospital for treatment. I was examined by police, and in fact, I gave my signature statement to police in my own handwriting, under my own signature. After I got the call from JVK EMRI call center, I called the person who informed them from my mobile phone. The said person introduced himself as Bharat Bora. When I reached the place of occurrence, I met aforesaid Bharat Bora, who was in fact the husband of the victim. Exhibit 6 is my aforesaid statement in my own handwriting. Exhibit 6.1 is my signature. Pros. I have passed
What is Exhibit 6?
page 114.
This is the first time I have come across this kind of
The 161 statement has been
This
executed.
161 statement
Page 114.
in the hand of the victim,
My lord.
in the hand of the
Yes,
witness.
yes. Recorded
This
by
is the first time I have seen. Where is Annex 6? Yeah, Exhibit 6.
114, my lord.
This is to be outrightly discarded
Page 114, my lord.
with perhaps 114.
Even the statement of the accused appellant was executed, my lord.
This is not to be taken into consideration. Absolutely. 161 is to be in the case diary.
Hmm.
Nowhere outside the case diary. How the PP has admitted that into evidence, we don't know. Perhaps I don't know.
Even that is yellow.
Hmm?
Dala, if there was some discovery or something else, then a different matter, my lord. There is nothing.
Now, how this something can be written by the witness
And the IO is to write.
and deposit,
Hmm.
submit it to the IO. This type of thing I have come across for the first time.
That also
Maybe
correct.
correct. There is different CRPC somewhere. Yesterday we have seen another IPC. Going beyond IPC. Now perhaps going beyond
CRPC.
CRPC.
But in the
That,
161 that is exhibited, my lord.
I gave my statement to police in my own handwriting, under my own signature. And what is CRPC? Signature of the witness is not to be,
Not to be 116. Yes, my lord.
is it not?
Yes, my lord. But in the 161, my lord, it is stated to be recorded by the IO, my lord.
This is to be
In the page 115, my lord.
alien to examination of witness. Police officer may reduce.
162 CRPC.
No, 161. Police officer may reduce into writing any statement made to him in the course of an examination under this section. And if he does so, he shall make a separate and true record of the statement of each such person whose statement he records. Right.
Well,
So it has to be may examine orally. And the police officer has to reduce
the writing. And not to be signed.
into
is-
writing any statement made to him.
Yes. And not to be signed is 162.
That is in 162.
Yes,
No statement made by any person to a police officer in the course of an investigation shall, if reduced to writing, be signed by the person making it. So that witness will say orally.
Oh.
Police officer will reduce it into writing. Right? And it will be part of the case diary.
Yes, please.
And this cannot be signed. Shall not be signed. Right? No statement shall not be signed. So here it is completely contrary to 161 and 162.
The page 115, Lordship will kindly see once, my lord.
Contrary to. Hundred.
115, my lord. It is signed by the witness, my lord, and it is recorded by the SI, my lord.
Respected sir.
My lord.
Respect. It is a letter.
In the backside, it is recorded by the IO.
Completely different handwriting. Complete different handwriting. He says specifically that
He has signed. He has
in my own handwriting. So this is a concept alien to CRPC.
Yes, my lord.
This is to be
Discarded, my lord.
discarded outrightly. Huh? No. No. এইটো মিলে আৰু এইটো কোনটো বেলেগ Oh.
Here only one thing is there, my lord. PW4 says that he calls the 108 ambulance, my lord. But as per PW10, my lord, the accused appellant has called the one.
Eyes are to be closed to the testimony of
10.
PW10.
10 says appellant calls.
10 closed.
My lord.
We are closing these two pages
My lord.
outrightly.
My lord. PW11 is the sister, my lord. Lordship had asked, my lord, who had informed the informant, my lord. PW11, my lord.
He is trying to shield.
Page
He
31.
is trying to shield.
Yes, yes.
Accused was crying, so and so, so and so.
The accused was crying, everybody has said it. my lord.
Accused was crying. After hearing PP, will decide whether it was crocodile or not.
My
You heard about crocodile tears?
Yes, man. My
It
humble
could
sub-
be crocodile tears also.
it can go both ways, man.
It can both ways. After hearing, I'm saying that
My
I said that after hearing PP,
because
will decide
yes, man.
whether it was crocodile tears or human tears.
Before that, he was busy in court.
That is that, my lord.
Said that he was crying.
Yes, yes, yes.
No, because when Lordship rose for the break, my lord, it came to my mind, my lord, there is a judgment, my lord. How a person reacts, it would be unique to that person.
Yes, you need to the person. I know.
Yes, my lord. Because somebody may react in an unnatural manner, but it will be
Somebody
normal for them.
keep mum, somebody may go silent,
Somebody
somebody may
In shock,
react,
my lord, they may just
shock, somebody may lose consciousness. Yes,
yes. Page 31 is the sister of the
but just kind of burning, holding the hand and crying without any effort to douse the fire. That is a suspicious circumstance. And that lady, old lady is saying.
my lord.
Anyway,
My lord.
PW11. Who is she?
Sister of the accused appellant, my lord.
Sister of the
My
accused.
cousin sister, my lord.
Is my younger brother. Okay, elder sister.
And my lord, PW1 says that the sister informed him, my lord.
Oh,
This is that lady, my lord.
elder. Okay, elder sister. Elder sister.
Kudmai Bora is my mother. I also knew the wife of the younger brother, Bharat Bora. She was late Bijoy Lakshmi Hazarika, alias Maina. She expired about 2 years back. On the date of occurrence, I was in my house of my husband at Porbatia Gao. The distance between my parents' house and the matrimonial home would be about 7 kilometers. On the date of incident, my cousin Shri Raju Bora informed me over telephone that
Rajagura was
PW3 3 informed me over telephone that Bijoy Lakshmi Hazarika Maina got burn injuries while lighting the gas stove in their own house. When I reached my parents' house by then, Bijoy Lakshmi Hazarika Maina had already been taken to the hospital. Thereafter, I went to Jorhat Medical College Hospital. When I reached the Jorhat Medical College Hospital, Bijoy Lakshmi Hazarika alias Maina had already expired by then. Later, Bijoy Lakshmi Hazarika alias Maina was cremated by our family members. I do not know how the occurrence took place. When I reached my parental home, I did not find my younger brother Shri Bharat Bora there. Later on, police came to my parental home and seized certain articles which were shown to my mother, Srimati Kudmai Bora. Exhibit 3 is the Caesar list. Exhibit 3-2 is my signature therein.
Wait, the Caesar list? 3?
$107, my lord. The stove and the cylinder was seized, man.
Yes.
My lord. It was the police who brought out the seized articles from my parental house. I saw police bringing and seizing the same from my parental house. To my knowledge, the relationship between my younger brother, Shri Bharat Bora, and his wife, Vijayalakshmi Hazarika alias Maina, was cordial and good to my knowledge. I do not know anything contrary to that. This is Vijayalakshmi Hazarika alias Maina was working somewhere else. On the date of incident, she was supposed to join another service. I used to visit my parental house and always met the deceased. She never told me of any act on the part of the accused Bharat Bora against her. PW 12, my lord. PW 12 is related to the informant, my lord. And he happens to be a police officer, my lord. PW 12, my lord.
Related to the accused. Paragraph 3.
Sorry, my lord. Yes,
Is it
related to the
not?
accused, my lord.
Is it not?
Yes, yes, my lord. What I
Related to
9, my lord.
accused. Accused Srimati Onumai.
Huh.
What was the name of the lady?
Kudmai.
Huh?
Kudmai.
Kudmai.
Pet name, my lord. Maybe,
Pet
maybe.
name. Is my own elder sister.
Yes, sir. What I was trying to say, my lord, page 9, my lord. PW1 says that he comes across PW12 in the hospital. Bimal was pardon, my lord. That is what.
PW Robin Kolita.
Yes, my lord. Page 9.
PW1 says.
Page 9. 10th line from the bottom, my lord. Leaving aside the cross part.
Okay.
Entering inside the campus of the hospital, I came across Robin Kolita,
Hmm.
who works in the police department. I told him there is suspected foul play in this incident.
Oh, accused was calling him. Yes.
My lord.
Accused was busy calling somebody.
Did not know.
This man. Come.
I did not know.
Police, your police uncle, come. Yes.
Page 33, my lord. The
Hmm.
incident occurred in the early morning on 14/8/2010. I was informed over telephone about the incident by my nephew, that is accused Bharat Bora. At about 6 a.m. to the effect that his wife Vijayalakshmi Hazarika Bora had caught fire from the LPG gas stove. On getting the information from my nephew, accused Bharat Bora, I informed the officer in charge of Dergaon PS, took his permission and proceeded towards the residence of accused Bharat Bora by my motorcycle. However, before arrival at the residence of the accused person, I came to know that Vijayalakshmi Hazarika Bora had been taken to Jorhat Civil Medical Hospital for treatment. On getting the aforesaid information, instead of going towards the residence of the accused persons, proceeded to Jorhat Civil Hospital. Lot of persons assembled in Jorhat Civil Hospital, including the accused Bharat Bora, his cousin Rakesh Bora, and the relations of Srimati Vijayalakshmi Hazarika Bora, including her parents, brothers, sisters, and others. I reached Jorhat Civil Hospital at about 7 a.m. By then, Vijayalakshmi Hazarika Bora had already expired following her burn injuries. The accused Bharat Bora informed me over telephone, as aforesaid, from his mobile phone to my number, bearing so and so. I met the cousin of Shri Bharat Bora, Shri Rakesh Bora.
This Rakesh Bora is PW? 4 perhaps.
Rakesh Bora is PW4 man,
Yes.
who is the son of elder paternal uncle of Shri Bharat Bora. I stayed at Jorhat Civil Hospital till about 9 a.m. But before I left Jorhat Civil Hospital, accused Bharat Bora had fled away from the hospital. I inquired the same from Shri Rakesh Bora, but he, Rakesh Bora, could not intimate anything positive regarding the same. Before I left Jorhat Civil Hospital, I found that Bharat Bora by then had escaped from Jorhat Civil Hospital. Therefore, I tried to contact him over his mobile, but I found that his mobile phone was switched off. Later in the afternoon, about 3 p.m., when I was at Dergaon PS, Shri Bharat Bora contacted me over my mobile phone. I instructed him to surrender before the in charge of Raudia police outpost. However, I did not have any information whether he abided by my request, advice or not. Shri Rakesh Bora lifted the cloth covering the body of Vijayalakshmi Hazarika Bora, and after seeing and observing severe burn injuries over the face of Vijayalakshmi Hazarika Bora, I went away from the location as I was in shock. I met Shri Suresh Hazarika, father of so-and-so, and father-in-law Bharat Bora at Jorhat Civil Hospital when I was present there. Shri Suresh Hazarika asked me as to what was my view after observing the dead body of Vijayalakshmi Hazarika, and I replied to him that I suspected foul play in the matter. Before the occurrence, Vijayalakshmi Hazarika Bora was working in the block office of Kakodonga block under Dergaon subdivision in the district of Golaghat. Accused Bharat Bora had been absconding for about 3-4 months prior to his arrest or surrender before police after 3-4 months from the date of occurrence. That is on 14/8/2010. My elder sister, accused Onumai, resides with her aforesaid son Bharat Bora. As aforesaid, after she Rakesh Bora who is the cousin of accused Bharat Bora, lifted the cloth covering the face of Vijayalakshmi Hazarika Bora, I came to the opinion that she did not get any burn injuries by accident and there was some foul play in the matter. Cross. I knew Suresh Hazarika, father of Vijayalakshmi and father-in-law of Bharat Bora, from before. As my elder sister Onumai, pet name, asked for some bride for her son Bharat Bora, I told regarding Vijayalakshmi Hazarika Bora to her, and thereafter the marriage between the couple took place. The couple, that is accused Bharat Bora and deceased Vijayalakshmi, went to my residence at Dergaon once. And I also, with my family members, went to the residence situated at Pokamora once. I used to meet Shri Suresh Bora, father of Vijayalakshmi and father-in-law of Bharat Bora, sometimes. From the date of marriage on 2/6/2010 till the date of occurrence on 14/8/2010, Shri Suresh Hazarika, father of Vijayalakshmi and father-in-law of Bharat Bora, did not inform me regarding any cruel treatment, harassment, or any other act committed by accused Bharat Bora to his wife, deceased Vijayalakshmi. When I reached Jorhat Civil Hospital at about 7 a.m. and stayed there till 9 a.m., I saw accused Bharat Bora having conversation with the relations of deceased Vijayalakshmi Hazarika Bora, including her parents. When Shri Rakesh Bora opened the piece of cloth covering the face of Vijayalakshmi, I only noticed her facial part, and I did not observe other parts of the body. I do not remember or recall whether I stated before police that I suspected some foul play in the matter. I did not make any inquiry or investigation on my own regarding the aforesaid incident. I do not remember or recall the exact date when accused Bharat Bora surrendered or was arrested by the police. It is not a fact that accused Bharat Bora had not been absconding for 3-4 months prior to his arrest or surrender before police. I do not know when the FIR was filed, when the case was registered, when and where police went for investigation. PW 13, my lord. He is the Gao Bora of the accused appellant's village, my lord. He has said that the accused appellant has made a extrajudicial confession in front of him. And this lordship, before I read this, my lord, lordship, I told my lordships that he signed it on 26/11/2010, my lord. Police, he signed it on 26/11/2010, my lord, before the next court below, my lord, CGM court. Then the police took his custody, my lord. On 38, they recorded his 161 statement, which has been exhibited, my lord. And then again on 2nd, my lord, they call PW 13 and PW 17 to the place of occurrence, that is the house of the accused appellant, my lord, to show as if for the first time the accused appellant had made the statement before the witnesses, my lord.
Yes.
Page 37, my lord, Gao Bora. I am the government Gao Bora of Kuhiaparia Brahmin Gao and Salia Gao under Raudia Police Outpost under Jorhat PS. I know and have identified both the accused persons, namely Shri Bharat Bora and Khudmai Bora, who are present in the dock of the court today. Both are residents under my lot area. On 2/12/2010, I was asked by police of Jorhat PS to go to the residence of accused Bharat Bora, and accordingly I went there. I was told by police that they have apprehended accused Bharat Bora. Prior to the date, accused Khudmai Bora was in custody after her arrest, and as such, the house of the accused persons was under lock and key when myself and police of Jorhat PS reached there. When I reached the house of accused Bharat Bora, it was decided that the lock should be opened and a site plan of the place of occurrence would be prepared, as showed by accused Bharat Bora, and accordingly the same was done in presence of myself as well as police. The place of occurrence was a bedroom having one bed and other household items which were shown to by the accused Bharat Bora to the police. Later, we were shown an open veranda as well as the kacha kitchen by the Accused. Accused Bharat Bora was interrogated by police in my presence. I heard everything when Bharat Bora stated before police. Accused Bharat Bora stated in my presence to the effect that in the late night intervening night between 13/8/2010 and 14/8/2010, his wife Vijay Lakshmi had gone out to answer nature's call to the urinal which was situated outside the house. After Vijay Lakshmi Bora returned to their house after answering nature's call, accused Bharat Bora wanted to have physical relation with his wife, Vijay Lakshmi. His wife, Vijay Lakshmi, showed her reluctance and did not agree for the same, which led to some dispute Hazarika of the occurrence. Police examined me. It is a fact that I stated before police to the effect that in cross he has not resigned from his 161 manor. It is a fact that I stated before police to the effect that when I asked accused Bharat Bora about the incident, I came to know from the accused Bharat Bora that he murdered his wife by strangulating her, that he wanted to have physical relation sex with his wife when she was in the kitchen, to which his wife refused, and thereafter some altercation quarrel took place in between them. That due to the aforesaid altercation quarrel, the accused Bharat Bora strangulated his wife Vijay Lakshmi Hazarika Bora with the help of the sari which she was wearing. That he thereafter pushed his wife to the gas stove, which was burning at that time. That after the aforesaid incident, he shouted for help, and nearby people also came to the place of occurrence. Thereafter, his wife was taken to Jorhat Civil Hospital in a 108 ambulance. About 1 month prior to the date of occurrence, deceased Vijay Lakshmi, wife of accused Bharat Bora, came to my residence for obtaining a certificate from me. From then, I came to know her and remember her name. I also knew that she somewhere works at Pokadonga near Dergaon, under Golaghat district. I can still recall the face of Vijay Lakshmi. Material exhibit 1, 2, 3, and 4 are her photographs. Defense cross, my lord. The distance between my residence and the residence of the accused person would be about 1 kilometer. As the village headman Gaambura, I knew the family, but I do not have any visiting terms or close acquaintance with them. It is a fact that police recorded the statement of the accused Bharat Bora in my presence. The entire thing would be hit by 25-20 of the Evidence Act, my lord. It is not a fact that accused did not show the police and myself his bedroom, then the veranda of their house, the Kacha kitchen, as stated by me during my examination chief cross-examination by the prosecution. I was not alone when accused Bharat Bora made the aforesaid extrajudicial confession, as stated by me during the cross-examination by prosecution. It is not a fact that I falsely said that Bharat Bora made extrajudicial confession that he strangulated his wife and murdered her. It is a fact that Bharat Bora did not tell me that his wife got hurt in her ears when she tried to resist him, when the accused Bharat Bora tried to have forceful sexual intercourse with his wife. However, it is a fact that Bharat Bora stated before police as well as before myself that he tried to have sexual relation with his wife, and that his wife refused. It is not a fact that Bharat Bora did not state before myself as well as before police that he again wanted to have sexual relation with his wife when she went to the kitchen. It is not a fact that Bharat Bora did not state before myself as well as before police that he strangulated his wife with her chador. I cannot say whether deceased Vijay Lakshmi expired as a result of burn injuries, which she suffered accidentally or not, by the gas stove, as I was not a witness. It is not a fact that I have deposed falsely today in the court. It is not a fact that whatever I have stated during cross-examination by the prosecution is not true and correct. It is not a fact that Bharat Bora did not state before me that he tried to have sexual relation with his wife, Vijay Lakshmi, in the presence of police. He was again re-examined, my lord, page 42. I have deposed in this case today. Today, I have got someone from this court to depose my statement. I gave my statement on section 164 CRPC in connection to this case before this court. Exhibit 13 is my statement. 13 so and so is the signature. On behalf of defense, my lord, police interrogated the accused. He was standing outside at the veranda at that time. The accused was interrogated in a room. I cannot say as to what questions were put to the accused by the police and what he said to them. I gave my statement as per information issued by the police. That's page 42, man. Page 43, PW 14 is a doctor, my lord, PM doctor. There are 4 wounds on the deceased, my lord.
Or
wounds, my lord, injuries, my lord.
Hmm.
One is superficial burn injury, lordship is similar, wounds, position, size and character.
Front.
Superficial burn injury present at the front
and side.
side of the neck, externally up to mouth, in externally, and upper 1/3 of anterior chest.
Hey, Modi can say.
On dissection, tissues found were pinkish in color with a horizontal tissue mark showing abrasion in the upper part extending from one side to the other side anteriorly.
Injury sourcing and supervision.
Contusion also seen in lower part of the neck tissues on the sides. Both eyes were congested and showing petechial hemorrhage. But here, the larynx and hyoid bone is not shown, my lord. It is there in the PM report, my lord. It is not fractured, my lord. It is congested.
Higher bone is related to what?
Strangulation, my lord.
Perhaps hanging.
No. In suicidal hanging, my lord, hyoid bone will not be broken. But in strangulation, my lord, or throttling, my lord, the hyoid bone, as per Modi, is normally broken, my lord. There is fracture of trachea, larynx, and the hyoid bone.
In manual strangulation also.
Yes, as per Modi, my lord. There's a table, my lord,
Let
showing
us
the
see.
difference between
Modi also.
suicidal and strangulation, my lord.
Exhibit what is it? Exhibit.
Page 118 is that the PM report, my lord. Well, larynx and trachea congested. Point number 3, my lord. The opinion, my lord, page 4. In my opinion, the cause of death was due to asphyxia as a result of strangulation sustained by the deceased. All the injuries sustained by the deceased is homicidal in nature. Time since death is more than 6 hours. The asphyxia was caused by strangulation. However, as the victim had suffered burn injuries from the face to the anterior part of the chest, including the neck, it cannot be ascertained whether strangulation was caused by bare hands, by some object like rope, cloth, etc. The Lordship will kindly see, my lord, PW 1, 2, and 12, and the others, my lord. They had said that they saw a black mark on the neck that is about 1 centimeter in width, my lord.
Hmm.
Here the doctor says that there is no such mark, my lord, due to the burning, my lord. The defense side has done cross-examination, my lord.
Person removed from houses.
The defense process, my lord, whether the victim died of hanging. Answer: hanging would have caused fracture of one part of the cervical spine. On postmortem examination, I did not find any fracture of the cervical spine on the victim. So hanging
Hanging is ruled out.
clearly ruled out.
You have elicited that.
Yes, ma'am. But also, my lord, certain aspects as per Modi, my lord, are missing them. For strangulation, my lord. And page 46 is one of the IOs, my lord.
From the postmortem report, it is superficial burn injury.
Superficial burn injury. my lord.
Superficial burn injury means I've not found anything
It's not in Modi, my lord. I have not found, my lord.
situated. Superficial means in anatomy situated at or close to a surface. Superficial blood vessels are those close to the surface of the skin.
Yes, ma'am.
It has gone deep. It has not gone
It
deep.
has not gone deep. Yes. And then the
Then,
second point
then
on dissection, tissues found pinkish, my lord.
we'll see to that.
What happens?
One more issue is that asphyxia,
Asphyxia.
right?
Yes, my lord.
Asphyxia is
Loss of air in the
suffocation,
loss of air in the malab, this part.
a life-threatening condition in which oxygen is prevented from reaching the tissues by obstruction or damage to any part of the respiratory system.
My lord.
Superficial burn injury will not cause any damage to the respiratory system. Yes, still from burning,
Smoke.
suffocation may result,
Smoke and yes, my lord.
but the situation is Modi as per. Persons removed from houses, destroyed by fire, are often found dead from suffocation due to the inhalation of smoke,
My lord.
carbon monoxide, and other irrespirable gases, which are products of combustion. In such a case, burns found in the body are usually post-mortem, but we do not find anything like this in this case. So this suffocation from inhalation of
Smoke.
irrespirable gases appears to be
My lord.
ruled out. So this asphyxia from suffocation from burning,
My lord. Yes, my lord.
not possible. In the
Given-
situation,
Given facts, my lord.
the old lady is sleeping on the bed,
My lord.
right?
No, here the entire case, my lord, the learned court, my lord,
This,
learned court below. my
we
lord.
have to see now the strangulation part.
My lord.
Yes.
The strangulation, Modi, your lordship, will kindly see. my
Dear
lord.
Modi, manual strangulation to Saho. Manual. Hanging is gone. Manual or suicidal. If hanging is gone,
Hanging is gone.
what will be the alternative? Tell me.
No, here, my lord,
With the dissection, the tissues were found pinkish. I was imagining a situation where I can do it in my own. I was imagining a situation to do it. Whether I will have that force to create such things. Contusion also seen the lower part
My hands
of the neck tissue on the sides.
that is the thing, my lord. On dissection, my lord,
Huh.
that internal tissue should have been contused, my lord. Here, there are severe abrasions on the upper part, extending from one side to the other side, 40 years.
Burn is gone.
Burn is gone.
Hanging is gone. Asphyxia is still there.
Asphyxia is still there.
And asphyxia,
Strangling with bare hand or with cloth?
huh?
With bare hand or with
Or
cloth?
And
clothes.
since, my lord, it was
It is with cloth, because.
Oh, bare hand or with rope? Rope.
Hand, Lordship, there will be some
Ah.
marks, Lordship.
Suicidal strangulation is not very common,
not common.
though sometimes cases are made with. In these cases, they are always made to keep the ligature tight after incision is done by twisting a cord several times around the neck and trying a knot, which is usually single in front of the, but twisting a cord tightly. One thing is sure that it is not possible for anyone to continue a firm grip of the throat by himself or herself, for the reason that after unconsciousness supervenes, hence throttling by the fingers cannot be possibly by suicidal because grip loosens.
They did
When
also.
you go to unconsciousness, the grip will lose. Grip cannot
Stay strong.
remain tight. So this, by own manual strangulation, that is also ruled out.
Mm.
But that is not possible at all.
Yes, my lord. My lord, what I,
Single turn of ligature around the leg with one or more knots. Sometimes there may be turns in which
what I was trying to point out, my lord,
yes.
is that just for argument's sake, if assuming, my lord, it was the husband who had done the strangulation part, my lord, it would have been of sufficient force, my lord. Then, as per Modi, my lord, the larynx, trachea, and the hyoid bone are to be fractured, my lord. And the underlying tissues are all to be contused, my lord. In this case, the mother was also there. I'm not saying that
Hmm.
for argument's sake, my lord. In the instant case, the PM report, the larynx and trachea are not fractured, my lord, they're only congested, my lord. Had it been the
That is what
husband, my lord,
is it possible or not? That is why we are looking
Yes,
at
my lord.
it.
had it been the husband with
Mostly
a male person, my lord, sufficient force, my lord, if applied, my lord, definitely it would have been fractured, my lord. Fractured or broken, or my lord.
hanging very well marked. Stress exposure minimal due to not showing abrasion. Hmm. External appearance, moody. Eyes. So far as external appearance, as regards eyes, the conjunctivae are congested. Sometimes there are petechial hemorrhages.
There.
Is there? We are not experts. We are trying to
Yes,
learn
sir.
only.
The tongue-
Yes, you according to this table, yes, it is true.
No, certain
That,
things are there.
yes, it is true that fracture of the larynx, trachea, and hyoid bone can be found in strangulation.
Certain
But
parts are
it is
there.
not
Certain parts are there.
sine qua non.
Yes, it is. No, I was,
It is not a condition
But
that
it should be.
every year it is to be present.
but that- what I
There
was-
are other signs also. Suffocation also. There are many ways. We are trying to find out whether
no, the
this.
tongue also protrudes, my lord.
Huh?
The tongue also protrudes, my lord, in strangulation. That is there in this case, my lord.
Where is the tongue?
Page 117, my lord. External appearance.
Hmm?
Page 117. External appearance.
Hmm.
My lord,
Oh, tongue protruded.
protruded tongue and rigor mortis.
Oh,
Certain
rigor
things are
mortis.
there, my lord. But
Superficial burn on dissection. It is not reflected in the
in the
pending.
in the
Oh,
evidence,
protruded tongue, it is there. Protruded tongue, it is there.
yes, my lord. What I was trying to bring my lord's attention to that is, my lord, had it been the husband, my lord, the force a male would have used, it would possibly should have led to the fracture of the larynx, trachea, and the hyoid bone. My lord. It depends upon the force. my lord.
Pointing, see the independent witness, the independent witness, the most independent witness. Most independent witness.
Doctor, my lord.
No. Whom you did not cross-examine.
The neighbors.
Neighbor, one of the neighbor. Let's say
6, my lord.
6. He says clearly the accused himself, his mother, Kudmai Bora, and the wife of the accused resided in the house of the accused. So you did not contest. So you were the 3.
The 3 of us, my lord.
You were the 3 in any view. And the incident had occurred at around 5 a.m.
In the morning.
There is no doubt about it.
Yes, my lord.
Because she was brought dead to the hospital. Under suspicious, let us assume for a moment, under suspicious circumstance, or it is a unnatural death. Unnatural death. Suicide is ruled out,
My lord, from our person. Yes, my lord.
not possible. Yes, by hanging, it could have been. Suicide by hanging was possible. By own manual strangulation, not possible. By rope, also not possible. So hanging is ruled out. So all kind of suicidal death is ruled out. So it is homicidal,
Homicidal.
the other alternative. If the other alternative is homicidal plus the burn injuries are superficial. And suffocation also, that the
Inhalation.
lady died by inhaling
Yes.
some obnoxious gases. That is also ruled out. So we are removing the possibilities. Now at 5 a.m., what is your explanation?
There is no explanation, my lord.
There is no
There
explanation.
is no explanation. No, but I'm trying,
And then tell me, apart from this,
but
because these PW 3, 4, and 5,
my lord,
we know the concept of related witnesses. Witnesses are related to the victim, right? And if they want to, and there are two categories,
interested and yes, my lord,
related plus
inimical,
inimical, then he is an interested witness.
interested.
Sometimes related may not be inimical.
Yes, my lord.
They may be natural, related, and independent witness.
They were the
Still
only
can be
persons present.
independent. Here is a case PW 3, 4, and 5. They are related to the accused, right? And normal human tendency is to shield the accused. And instances are galore that witnesses of this kind have a normal human tendency to, in such situation, to extricate the accused. How they are, because they are giving a different version, but still it can be decipherable from their testimonies that the lady was not talking despite having superficial burn injury. We are more convinced by the photographs also. At least an idea can be formed. She was not talking, nobody, but despite, suppose, only related, they are saying, projecting a subtly, very subtly, they are projecting a version, which is not true. But at the same time, something inherent, they could not suppress that which cannot be suppressed by them is that the lady was already silent. That is what bothering us. And as per the law now, tell me, what are the other things which was possible to be proved by the prosecution?
So what I would try to point out before Lordship is that had it only been the husband appellant,
Huh?
had it only been the husband appellant, only his presence is there, man, in the house, then definitely not only husband appellant,
Yes.
they
Both inmates owed an explanation.
both in
Right.
an explanation, man.
Definitely it will be argued, I know.
Yes, man. Now,
That both two inmates were there.
yes, man.
Both owed an explanation for the unnatural death of the deceased. Right? And this subtly, this PW 3, 4, 5, they have, and from the father also, of the informant. Relation was not that bad.
Relation was completely good.
Yes,
till that
cordial,
night,
we can understand.
till that.
But there may be some underlying thing which we, now what are the things which are, what you are saying?
But since there were two other inmates in the house on the same set
Two
of
is this accused and mother.
mother, since on the same set of evidence, the mother, because charge was 30 to 34, man.
I know this is coming. I have told my sister at the very beginning, this will be argued.
Since the charge was 30 to 34, my lord, the mother has been acquitted on the same set of evidence, my lord. Now, who has done the part of strangulation, my lord? It always remains in doubt now, my lord.
Yes, then what is the principle to be considered?
My lord, now the
That just because this
what I have-
co-accused under 34 has been acquitted, this man is entitled to be acquitted.
no, what I understand is that if the evidence cannot be segregated for the accused, my lord, it remains the same for all the accused. And on that kind of evidence, if somebody is acquitted, my lord, the other co-accused should also be
Because-
acquitted, my lord.
Yes,
Because-
this except sitting,
Except
except sleeping,
sleeping.
on
Mother
the
was sleeping.
bed. none of these
Because
18 witnesses or 17 or 15
mother was
has said something about the lady. Yes, 34 was brought in.
what goes in favor of the husband possibly is that he called the EMT, my lord.
Now let us see your 330.
313. And my lord, one more
Let
thing,
us
my lord.
see.
One more thing, my lord. What is evident from the evidence, as per my understanding, is that either the accused appellant kept silent to save the mother, or the mother kept silent to save the accused appellant, my lord. So 201 is made out, my lord. 201 IPC is possibly made out, my lord. But
No,
since
201 is not there. Evidence what is 201 is not.
because they
No
either
way.
they hid the real facts from the others, my lord, possibly, my lord. But 302, since on the same set, it cannot be segregated, my lord.
We'll see to that.
Yes, ma'am.
Hmm? No, ambulance. Huh? No. 125. No, who has exhibited this? No, this cannot be looked into. It was by PW 18.
PW 18, 161,
160.
one of the accused, my lord.
There is 164 statement also.
161 of the accused was exhibited, my lord.
Huh?
161 statement
Huh?
of the accused was exhibited, my lord.
That cannot be. That cannot be.
That cannot be.
That we are not looking into it.
My lord.
We'll not look into it. 124. Statement of the accused cannot be looked into it. Now we read up to what?
PW 14 was read, my lord. PW
Okay.
15,
This man is IO.
one of the IOs, my lord.
One of the IOs.
On 14/8/2010, I was in charge of Raudia outpost under Jorhat PS. On that day, the officer in charge, Jorhat PS, received one Ejaha from Shri Suresh Hazarika. The same was registered as Jorhat PS case number so-and-so under so-and-so. The charge of investigation was entrusted upon me by the officer in charge, Jorhat PS. During the course of investigation, I visited the place of occurrence and examined witnesses who were conversant with the facts and circumstances of the case. The place of occurrence was Pokamora, Kumargao, which is the house of the accused person. SI of police, so-and-so, held inquest of the dead body at Jorhat Medical College Hospital. I also drew the sketch map, the site of the occurrence with index. I also seized one gas stove, one regulator, one full gas cylinder from the kitchen of the house of the accused persons with the help of seizure list in presence of witnesses. Accused Bharat Bora was not present in his house at the time of seizure of the aforesaid articles. His mother, Khudmai Bora, was present in the house at the time of seizure, search and seizure. Accused Bharat Bora was absconding. Accused Shrimati Khudmai Bora was arrested by me in connection with the incident case. The photographs of the place of occurrence and the photograph of the victim was seized by me from the photographer, which was requested to be taken in by the in-charge Jorhat Medical College and Hospital outpost. After investigation of the case, I was transferred from the OP. Hence, I handed over the case to the officer in charge, Jorhat PS, which was completed by my successor. Then, my lord, after everything, my lord, the hostile part of PW3, my lord, that has been placed before the IO, my lord.
That is also not the way
That is also not the way, my lord.
to do it.
The entire statement has been, it has to be marked as per.
That is not the way.
And another thing, my lord, PW3 completely resiled, my lord. He did not admit, my lord. So that hostile part also does not come into play, my lord, possibly, my lord. Then the PW8's hostile part was also put, my lord.
Yes, I have seen. Come to that part has nothing. This
My lord, this
extraction of the entire statement of PW3
3 and
and
8,
PW8 do not go for any benefit to the prosecution also,
Yes, please.
right? Now, your cross-examination also did not elicit except that statement of the informant was recorded on 25/8/2010.
Delayed, man.
Otherwise also, he stayed at a different place.
He-
He had arrived at a later phase.
No, he came in the morning itself, man. 7
Came in the morning, but still, by the time the lady died,
Yes, yes.
and the witnesses PW 3, 4, and 5, they were to the place of occurrence, at least immediately after the occurrence. You can say in the course of same transaction,
In a way, man. Yes.
in a way. But this man, he stayed at a different place. He can say, yes, marriage was solemnized. After so and so days, the incident happened. There was incident of kicking, one incident of
Yes, one
kicking.
line.
Otherwise, they were visiting terms. Their relationship appeared to be cordial. That lady was working and lady was supposed to join in a new assignment. These are the things. Then plus at the hospital, what transpired,
Well,
what he had seen on the dead body,
it is
and the act of vanishing on the part of the accused from the hospital itself,
Mm.
meeting that uncle police officer of the accused. These are the things from PW1, I
Right.
said. From clause of I also, there is nothing except this statement.
Only that part, yes. ma'am.
Only that part.
Yes, ma'am.
This part is that some delay statement was recorded.
Yes, ma'am. Then PW.
Anyway, these facts, I don't think these facts are disputed. What I have just said about PW1.
Yes, ma'am.
Neither the kicking part was disputed.
Kicking part was not disputed. ma'am.
Not
The
disputed,
kicking
cross-examined.
part, in the cross, it said that he has not said the same in the FIR.
Denied.
Denied.
Now come to
16 is the inquest DNA.
inquest page,
50, ma'am.
report.
Hundred and three, ma'am. Page 104, point number 10, madam.
This man has some understanding. It appears so. At least he is the most independent, one of the independent witness.
No.
Though death is reported to be due to burning, but in view of partial burning of the upper part only, and no burning of the clothes as such, death might be due to often, I don't think often, other. It should be other. Page 105.
Other factors also. Yes, ma'am.
It should be other, I think.
It should not be often, madam.
Exhibit. This is exhibit
This is exhibit, my lord, 2.
2. Exhibit 2, 2, 2. Inquest. Other factors. Right.
Yes, ma'am.
It should be other factors. So death as reported relation between was not good. Somebody had told him. Death might be influenced by other factors. Okay.
That was at the
To ascertain the actual cause of death, postmortem should be was advised. And it was at 11 a.m. 11 a.m. that morning itself.
yes, ma'am.
This much he has said.
Inquest was 11. Postmortem was 1
PW
o'clock.
6. Postmortem was advised.
Postmortem was at 1 o'clock, madam. On the same day.
Okay, then PW 17.
17 is
Who
exactly.
is he? Oh,
He-
that
He's
Rubin
similar-
Kolita.
It's different Rubin Kolita, my lord.
Different Rubin
Different
Kolita.
Rubin
Okay.
PW 17, my lord, is similar to PW 13, my lord. He was also called by the police on 2nd of my lord, December, my lord, for that extrajudicial confession. My lord. Entirely same, my lord.
Who is PW 18?
Lord, one thing in PW 17, my lord, page 55. Lordship will see the last lines, my lord. Police came with me when I came to the court for giving my statement earlier. I gave my statement as per the dictation of the police. The learned court did not give me time for refresh.
Oh, when his 164 statement was recorded? Exhibit 14 recorded on
It says recorded on 23rd of August 2010, my lord.
20.
That is possibly wrong, my lord. 20th,
Where is that? Exhibit 14?
131, page number 131, my lord.
131.
131, it is possibly wrong, my lord. 132, it says 28th of December 2010. my lord.
28th of December.
2010. my lord.
So 2012, 2010. So 2012, 2010, his statement was recorded.
My lord.
And
212 and
it
20
was on 2/12/2010. He went to the house of the accused.
Yes, that night. my lord.
And whatever was deposed by him was about what the accused told
In
to
presence of
police after his surrender on.
2611.
So there is nothing to be
My lord. What I was.
used
Yes, my lord.
from
26
this man.
Yes, 2611 is surrendered. 38th,
Right.
his custody was taken.
Yes.
38th, his 161 was recorded, my lord, not on 2nd.
Huh?
His 161 statement was recorded by the police on 30/11/2010, man.
No, where is the question of 161 has come?
Because as per PW 13 and 17, police interrogated him in their presence for the first time, man, stating all these things, man. But his 160 was already recorded by the police on 30th of November 2010, man. And thereafter, police again.
We do not require to go into this. The accused was arrested
Surrendered.
or surrendered or taken into custody, whatever,
Right.
20 in November.
November.
Then after arrest, he was taken to his house,
Police custody, yes. ma'am.
right, by police in police custody. And somebody he had uttered. And these two witnesses, PW 13 and 17, they had heard. So it is clear that 25 and section 25 and 26.
Why I'm placing this, my lord, is that because he had absconded,
Huh?
accused had absconded, my lord. In 313, he says that due to fear of beating by the public, my lord. But he surrenders, my lord. That possibly that my abscondence is conduct as per section 8, my lord. Even the act of
Both
the,
it cuts both ways again.
yes.
It cuts both ways again.
Conduct of the police in doing this, my lord.
It may cut both ways, but
That is what
you may
yes,
might
that is also section
you
8, my
might evade arrest due to fear of police, or you might have
Because I've
absconded
committed the crime.
because you have committed the crime. Both.
Yes, ma'am.
This factor is to be.
Yes, from the hospital itself, when
Yeah.
it has come to his knowledge that.
That
apparently
is the uncle
lost,
we have
immediately
told it, police told me
That
to.
as soon as
In 313,
the police was consulted,
in 313, he have admitted.
We have not reached, okay. We have not reached. Mr. Mahadana is taking us through everything. So, yes, yes, we have to understand also.
I think extrajudicial
Yes.
confession, Lordship, using the chadar, the strangulation part, where he have done extrajudicial confession, for just a moment. It may be, because the saris he is wearing.
Okay, you tell me then when your turn comes. Your turn comes. Yes, PW 18, 18, anything?
18 says that accused appellant surrendered, and 18 exhibits the 161 statement, my lord, of the accused appellant.
What? Accused statement. This all IO, PP, all are in the same boat. All are in the same boat. If there is no leading to discovery, nothing. If leading to discovery, also the material part is to be exhibited.
Only that particular part. Then
What to do?
Then 19, my lord, another IO, because 13 and 17 became hostile, my lord, their statements were also brought on record. The entire
13 and 17.
Yeah.
Were they?
The
That 164.
extrajudicial confession, my lord.
Have made efforts, but something not very. Syamal Kumar Bonia appear and court or receive depose. Investigation since disease. Okay, somebody died. Vinod Setia. Who is this?
They have SIO police, my lord. The earlier, one of the earlier IOs.
Witness Robin Quayle's statement. Approach.
This Robin Colita, I do not know which Robin Colita is talking about.
Oh, you surrendered before court.
Yes, yes, ma'am.
Then after 4 days, police
custody was
took
taken.
you in custody.
On the day my custody was taken, by 160 on the record.
এইবোৰ কিবা কাম আছে নে এইবোৰ যিমানবোৰ দেখাইছিলে unnecessary কিছুমান হা
Then, my lord, the 313 of the mother is page 61, my lord.
1 minute. Leading to discovery. What page 60? What leading to discovery?
No leading to discovery. That is.
Yes, let us see 313 now. Khudmai.
Khudmai, my lord. No real explanation, my lord, only denial, my lord.
Falsely implicated. I did not make cruelty upon my wife. Here comes the copy-paste business. Khudmai Bora, page 62. Answer to question number 2. And this is a false explanation. She received burn injuries while boiling water over the gas stove. This is false.
And acquitted.
Now, this is completely false.
And that
because this kind of injury will go into the lower part of the body, not to the face. Face and neck. This is a false explanation
Yes, ma'am.
by the lady, mother-in-law.
Same copy paste is the son, my lord.
And their copy-paste is because I did not cruelty upon my wife, she said.
Yes, ma'am.
Mother-in-law. So this is copy-paste business. First, the this husband was asked and copy paste was done.
Page 67 is the husband, my lord. Second question.
Same answer? Okay, let us see. Scrutinize every answer. The witness deposed. I do not know what doctor had written. I do not know what police had written. I do not know what the magistrate had written in the inquest report. I may be acquitted. I am an old ailing lady. Okay, now let us see the accused answer.
Page 66, my lord.
I did not. This is false. The part of the body, the burning, second part of your answer of question number 3 is also false. I was all along present in the hospital along with my wife in the presence of this overwhelming evidence of even your cousin brother.
He was there till the police came, man. He met the deceased family as well, man.
It's not all along.
Yes, ma'am.
Police
Asked me to stay away.
Police will never ask.
Yes.
This is also false.
This is his uncle, lordship.
But uncle is deposing against him.
Uncle deposed against me.
Please surrender.
Surrender, but that is thing, lordship. Uncle have already informed him, you stay away.
Uncle informed now, when before the court, he will not say, stay away. He has said, I asked him to surrender, since you have been implicated. But contrary to your uncle version, you are saying now. I was all along, wife in the hospital. I was not present. Do not know anything. I was present. This witness met me.
My lord,
Done.
Page 67, my lord. Question 2 and 3, my lord. Sorry, question 3 and 4, my lord. The learned court below is taken a circumstance that PW2 and PW3 saw the black mark on the neck of the deceased, my lord. But that circumstance has not been put in my 313.
We can examine him.
Huh?
We can examine this man directly. We have that power. If you want to put him
No,
to
no.
that extent, we can examine him. And we'll rigorously examine him
319, my lord.
under 313. Okay.
Yes, ma'am.
That part was not put to him. Okay.
And page 75, again, my lord, 2 more questions were put, my lord.
75.
Nothing specific, my lord.
You leave this part, PW 13 and
Yes, yes.
17. They are of no value
Then, my lord, coming to the
to anyone, neither prosecution nor defense.
When coming to the circumstances, the court relied upon, my lord, 95, my lord.
95. Yes, one is not disputed.
One is not disputed. 2 and 3
Two
possibly.
is not very,
2 and 3 possibly go, my lord.
not very
Not
well
even-
established. Inference maybe, but even inference quarrel is not there.
Not there.
Quarrel is nobody had deposed. That hostile witness deposed, but That is to be out of consideration. And appraisal remain on second. 3 is to be
Yes, ma'am. 4.
Raju Bora, Rakesh Bora, Thunumay Bora. Raju was hostile,
Raju was hostile, ma'am.
but still a part of it can be taken.
This part is, yes, ma'am. They took him to the hospital.
Some parts. Then
Then absconded.
these witnesses are related to the accused,
Yes,
not to the,
this is.
not as close as to the disease.
This is.
So there, but one thing has emerged clearly that lady was not talking.
Not talking.
No, no.
Lady
was
was silent. Then accused absconded 3 months.
But one thing.
It is a fact.
One thing, my lord. The lady was first taken to Mission Sariali Hospital, madam. And then taken to Johat Medical, madam.
No, but this is to be discarded, that man, ambulance, straight away thrown to the dustbin.
Chief also.
Oh, yes, everything.
Yes, ma'am.
Whatever he said in that written statement is the same in the chief.
Same the chief.
This ambulance driver is clearly hand in glove.
Hmm.
No doubt about it.
Then, my lord, 5, the abscondence part, my lord.
Why the trial court had accepted,
No.
so cause is to be given to him, should have been given to him. As to why
He stayed for.
prosecution should not be launched against him. Yes, 5.
Absconding.
5 abscondence,
Ah.
my lord.
It has been taken as a circumstance.
It humble submission goes both ways, my lord.
Goes both ways.
6, my lord. I have placed, my lord. It has not been put, my lord. But still inference can be drawn, my lord. 7 is where it gets stuck, my lord, possibly in my humble submission, my lord. Because same set of evidence when it cannot be segregated, my lord. Mother has been acquitted, my lord.
Okay.
Humble submission, my lord. Because who has then committed the actual act, my lord? That will always remain in doubt, my lord.
There is a theory propounded by the Supreme Court also in such situations.
Yes, my lord. That will possibly always remain in doubt, my lord.
That 34, 2 persons have been roped in, 1 has been acquitted by the trial court.
Hmm.
What will be the situation? And since MS Begum has not preferred any appeal,
And my lord, my
anything to support,
possibly I've got to my limited
anything to support that 1 is acquitted, so other is to be acquitted
the
without looking into the evidence by the appellate court.
No. That is not the is not the-
Because
that is-
otherwise you have to close our eyes and to acquit.
no, that is not the
It
proposition.
cannot be.
Cannot be, my lord.
Then what is the principle for appreciation?
If the evidence, my lord, it cannot be segregated and broken into parts so as to convict one or acquit one, my lord.
What is the theory? Suppose this A2, accused number 2, accused number 2 had been acquitted by the trial court, right? Prosecution did not prefer an appeal. Can it be possible for the appellate court to evaluate the entire evidence on record as if A2 was there? And 34 would have been, please, let me conclude. Let me complete my sentence.
I beg my lord's pardon.
As if A2 was there and had the trial court properly appreciated the entire evidence on record, A2 ought not to have been acquitted. Proceeding on the basis thereafter, since A2 had been acquitted, he cannot be, in the absence of an appeal, that cannot be reversed. Order of acquittal cannot be reversed. But he ought to have been convicted also. Can, in that manner, the appellate court can evaluate the evidence? Because it is a continuation of the original proceedings otherwise. Accept acquittal of the A2. Is it possible or not possible?
It is possible, my lord.
Possible, then possible.
That, my lord, the acquittal of A2 would be a circumstance in then my favor, my lord. Because it breaks the prosecution story, my lord.
Okay, what are the grounds for acquittal? That is the only paragraph, paragraph
That
37.
is the only paragraph, my lord.
Then
My lord, the
Roman 8,
it took place within 2.5 months, my lord.
evidence.
I'm the medical officer, my lord.
This part you have not been able to disprove, dislodge.
Well, here what I would,
And the other theory now, that you owed an explanation. See, there are 3 inmates. Now A1 and A2. That theory you are submitting. A2 is acquitted on the same set of evidence. It cannot be disaggregated for A1 or A2. So, on the same set of evidence, A is also to be acquitted. That is one part. Now, so far 9 is concerned, that is not dislodged. We have seen the Modi also and the various meanings also. Now, what will be the next? You owe an explanation. Otherwise, there is not even by suggestion also.
suggestion was given against the defense itself, my lord, by the defense only. That I would not say anything on that, my lord.
So, there is possibility of any third person doing the or the perpetrator for the unnatural death. It is ruled out. There is no third. These 2 remained.
Nine
My
lordship,
lord, now the
husband also did not switch off the regulator lordship. It
That
shows that
other man,
he could have, by burning, he could have.
he was crying. It appears to be a,
Not even switch off the.
he was crying.
so that my humble submission is
Perhaps
I do not
not
know.
human.
My lord,
Perhaps the other one, crocodile.
that is not on record, my lord, possibly, my lord. That is possibly not on record, my lord.
Holding the hand, oh, you are going,
Go.
goodbye. Could be,
My lord.
or could be.
But some-
He was very sad
my
also
lord.
and perplexed what to do.
Yes, my lord.
Maybe he was in traumatized that he will also burn himself. So he had not.
So, madam,
My lord, now the non-explanation by the accused, my lord. I would say this, my lord.
not only non-explanation, false explanation,
False
also, at least
explanation.
3.
3 years, my lord. It would be that, my lord, whether the mother was trying to save the accused appellant or the accused appellant was trying to save the mother, my lord.
That we can, now, you are the accused. You have a right to remain silent, you have remained silent.
Yes, my lord.
Where there was possibility to provide explanation. You remain silent for both of you.
Now, my lord, the only circumstance.
Only the case is the falsity of the prosecution case. Somebody died, your daughter-in-law and wife died
My lord.
inside your house at 5 a.m. Yes, noon hours, 10 o'clock in the morning or 2 o'clock in the morning, 5 o'clock, one can visualize. There is possibility of something, some person more or some region other than, but here at the 5 o'clock,
That's why I placed before my lordship, my lord, because had a male person done the strangulation part, my lord, it would have been sufficient force, my lord, to fracture everything, my lord.
sufficient, it was there.
But it is not fractured, my lord.
It is not a sign given on.
No, that is why I'm trying to just bring out the distinction, my lord. If the old lady, just for argument's sake, does it, my lord, it may not lead to a fracture, but yes, strangulation may occur, my lord. But husband in anger does this, my lord.
Oh, you know how much force is to be given.
No one would know, my lord, because in the heat of the moment, it has been done, my lord. Whatever has happened.
May not be heat of the moment. Maybe a pre-planned one. We don't know. We cannot go into that. We cannot enter into the mind of the
It was not pre-planned, my lord. That is not pre-planned. The premeditation is not there.
whatever, but the circumstances
Because till 13th, my lord, nothing. Everything is good, my lord.
good.
13th night, 14th intervening night.
Yes, you should have provided the explanation. Now tell me, what are the other things possible to be proved by the prosecution? That is my question. What are the possible things that were possible to be proved by the prosecution?
My lord, that
Which one?
motive, my lord. Till 13, there is no motive to kill the wife. My lord. Then, my lord, cordial relation as per most of the witnesses, my lord. Then, my lord, it is not that something has been discovered from his statement that I would not place, my lord. And it is not that the deceased was found in a place solely in the exclusive possession of the husband inside the house, my lord. She was found in the kitchen, my lord. Kitchen may be accessible to the mother-in-law, sorry, mother or the accused, my lord. That, my lord. And his conduct, my lord. His conduct, I would say that he calls the doctor or he takes her to the hospital. He is there, my lord. The mother-in-law is nowhere to be found, my lord. Yes, from the hospital he vanishes. And then later on, 3 months later, he surrenders, my lord.
Mother-in-law was lying on the bed. Who said?
PW 5, my lord.
5.
4, sorry, my lord. PW 4 said, my lord.
Page 18. Another accused, when I visited the place of occurrence, my aunt, another accused was lying on the bed as if she was suffering from blood pressure. And what that old lady was saying? Huh?
The accused was also in aiming condition in at the tent.
Page 21, last line.
Page
21.
Cross.
Last line.
Last tent.
This fracture part is totally, nobody has said this man. Yes, anything?
Okay, place some judgments, my lord. Then I'll be. Ex-contents I need not place, my lord.
You did not provide answer to me. What are the process? Only motive. Motive is difficult to prove. It is not also sine qua non. Yes, in a case
Circumstantial
in a
evidence.
case resting on circumstantial evidence, motive assumes a significant role, but it is not always possible to prove motive. Even in absence of motive also.
This Nagendra Shah Lordship had seen on the last occasion as well, my lord. I place another copy, my lord.
Yes.
Paragraph 8 onwards. my lord.
8.
Eight 8.1, it is an admitted position that the deceased wife and the accused appellant were residing together at the time of her death, and requisite privacy was available to the appellant to perpetrate the crime. The postmortem report and the evidence of PW9 has established that the deceased died on account of throttling of her neck. The burn injuries were undoubtedly anti-postmortem injuries. The accused tried to mislead the court by taking a false plea that the death of the deceased was due to burn injuries. The prosecution showed fairness by implicating only the appellant and not his family members. In paragraph 10, madam.
How many were there?
Madam.
How many inmates were there? Let us that I discovered on the
Father-in-law, mother-in-law, accused appellant, and
where is that paragraph?
Para 19, madam. 19, madam.
Para
19.
19.
In this case, as mentioned above, neither the prosecution witnesses have differs to the effect, nor any other material has been placed on record to show that the relationship between the appellant and the deceased was strained in any manner. Moreover, the appellant was not the only person residing in the house where the incident took place. And it is brought on record that the parents of the appellant were also present on the date of the incident in the house. The fact that other members of the family of the appellant were present shows that there could be another hypothesis which cannot be altogether excluded. Therefore, it cannot be said that the facts established do not rule out the existence of any other hypothesis. Then it goes on to talk about 106 and everything, Manu. Para 23, 24, 25.
What was the delay?
Manu.
What was the delay in lodging the FIR in this case?
On 18/11/2011, it was reported that the appellant's wife died due to burn injuries. Same day, possibly, Manu. Para 4. Paragraph 4.
And who were the accused?
Only the husband, Manu. I beg my lord's pardon, my lord. I beg my lord's pardon, my lord. 18/11/2011, a UD case was registered, and the PS case was registered on 25/8/2012, Manu.
25/8/2012.
5/8/2012, Manu.
25/8/2012.
But the investigation started from 18/11/2011, same day, Manu.
FIR. About 9 months.
Yes, Manu. But it started from the same day because UD case was lodged. On the basis of the UD case, the postmortem was done. the postmortem findings were
On the
made.
basis of direction of the senior police officer,
Yes, Manu.
FIR was lodged.
But postmortem was done.
It was posted as
Immediately.
friends of the first incident. The history of the accused was committed charge in submitted and none of the witnesses have supported the postmortem was discussed.
Postmortem was
Contents of the postmortem report.
paragraph 7, Manu.
7.
The learned, the state of the art submitted that the defense of the appellant of deceased died due to burn injury sustained by an accident of fire was proved to be completely false, as can be seen from the postmortem report. the deposition of PW9 Dr. Ashok Kumar Tiwari, who conducted the autopsy.
Postmortem is not discussed.
He pointed out that PW9 categorically stated that the death was due to asphyxia. He submitted admitted the repellent and the deceased was
Not
saying
discussed.
that much is discussed.
Not discussed. That much only.
That much only. That was false, my lord. Yeah, whatever.
Yes, Gargi.
Gargi is reverse, my lord. Wife has killed the husband, my lord. Paragraph 2, my lord. Here, my lord, the circumstances were that she had illicit relationship. The deceased, before his death, had suspected that the wife might kill him. My lord.
Hmm.
Lordship, can you turn the page, my lord? Paragraph 3. Prosecution case had been on 1/5/1997, having
Paragraph 3.
1/5/1997. It is found that the man has committed suicide in house number so and so.
Paragraph 3.
My lord.
Hmm.
On 1/5/1997, the deceased had committed suicide in the house of so and so. That is the matrimonial home, my lord. Okay.
Matrimonial.
Yes. my lord. Well, their house, my lord. Accused and the deceased, my lord. In paragraph 26, my lord. The main plank of prosecution case against the appellant has been that the relationship between the deceased and the appellant were too strained. The appellant was having illicit relations and was ill-treating the deceased. The deceased had even expressed threat to his life at the hands of the appellant. And the deceased was all set out to move out of the company of the appellant. These factors, imputing motive on the appellant to kill her husband, and even deceased perceiving threat to his life at the hands of the appellant, have been held proof by the trial court and the high court with reference to the testimony of so and so, so and so, so and so. These were the circumstances, my lord. And then para 33.1, my lord. Insofar as the last seen theory is concerned, there is no doubt that the appellant, being none other than the wife of the deceased and staying under the same roof, was the last person the deceased was seen with. However, such companionship of the deceased and the appellant by itself does not mean that a presumption of guilt of the appellant is to be drawn. The trial court and the high court have proceeded on the assumption that 106 is the evidence that directly operates against the appellant. In our view, such an approach has not been free from error, where it was omitted to be considered 106 does not absorb the prosecution of its primary burden. And 33.2, my lord. Here, what has happened, my lord? On 33.2, my lord, on 28/4/1997, when he allegedly expressed his dejection and fear and also his plan to return with luggage, the appellant has pointed out that the deceased was with her in the morning of 29/4/1997. When he pointed out his tour program commencing that day with scheduled return on 3/5/1997. It is not in dispute that the deceased was regularly on tour for longer durations of about 2 weeks in connection with duties. The dead body was recovered on 1/5/1997, and as per post-mortem, the probable time that has elapsed between the death and post-mortem on 2/5/1997 at 12:30 p.m. was 24 to 72 hours. On the basis of this opinion, cannot be assumed by way of arithmetical calculation that the deceased might have met with his end on 29/4/1997. The possibility of it being a day later is not ruled out. That the appellant met the husband on 29/4, my lord, and he ended up dead on 1/5, my lord. But it
But
is,
it is not such a case.
yes, but
You have not raised anything like that. You were not
here
in the
is,
house.
yes, yes. What I would tell,
But this here, at least it has been by at least preponderance of probabilities.
At least 12
the
hours
gap
is there.
between the point of time when the appellant and the accused were last seen together and when the disease was found, it had not been had not been that small, that possibility of any other person being the author of the crime is
But
rendered
here, Lordship,
totally
you kindly see,
improbable.
my lord.
But here at 5 o'clock, you were there
Yeah.
inside the house. And it
This-
is not the case that you were not in the house,
Yeah.
inside the house during the night also.
Here, what
You have not raised anything. Every case is a case based on its own facts. The principle is there, but principle is to be applied to the
facts.
what are the facts. Now here it is not that
Yeah,
you have not raised anything
because she,
so far
the
by way of even suggestion. No, I was not there for the night. I went and was with a friend drinking in his house. No? Having meal in his house. That day we
See.
huh?
That is the,
but that gap that has been shown in this paragraph, my lord, the deceased then came back and committed alleged suicide in his own house, my lord. And that day, but the deceased was there, my lord. The appellant was there, my lord, in the morning.
No, but operated that arithmetic calculation was done on the
In-
postmortem
In
report.
between, he died.
It
and his
re-
body-
relate back the time,
Yes, my lord.
relate back the time, then that is not possible when the lady was last seen with her husband.
My lord.
That is the, so there is a time gap.
And the allegation in this case was that the deceased, the appellant, along with her brothers, had committed the crime, my lord.
But PW 3, 4 and 5, they came immediately. There is no doubt.
My lord.
You were there calling your uncle. And lady was sleeping because of hypertension, that old lady. Now, you have not raised anything that you were not there. Being the husband and wife, you will be together more close during the night than your mother with your wife.
My lord. But that is the thing,
It
my
is
lord,
very easy to,
not found in the bedroom.
we can draw by process of reasoning certain presumptions.
My lord.
But how do you rebut those presumptions?
Because the lady was not found in the bedroom, my lord. Lady was found in the kitchen, my lord.
Wazir,
That's logic, it will not apply here.
And para 36, my lord, that co-accused acquittal, my lord.
Okay, that will consider. That will consider.
Para 36, my lord, that co-accused acquittal, my lord.
Yes, I have read, at the very beginning I have read.
36, my lord. Yes, my lord.
When I said that, where is the judgment? I read and I forecasted that what Mahajan would argue at the end of his submission will be
Yes.
para 37. I said to my sister.
This is similar, my lord. This is similar, paragraph 37, my lord. This is also paragraph 37, my lord.
in Wazir Khan also lordship, he cannot explain his dispute that he was present.
Have you handed over this judgments to,
I-
no, MS Begum?
No, lordship.
No.
Hmm? Paragraph?
37, my lord. The facts are in paragraph.
Hey, doctor.
Facts are in paragraph 4, my lord. And para 37 are here.
There is
Right.
itu নহয় মানে ৰাতিপুৱা ৰাতিপুৱা দিছিলো যে থৈ দিয়ক এইটো থৈ দিয়ক Yes, what had happened in this case?
Here, my lord, two persons were there, my lord. One person instigated the appellant, my lord, to shoot the deceased, my lord.
Hmm.
The instigator was let off, my lord, acquitted, my lord. Then this observation, my lord. There were eyewitness accounts, my lord, but they were disbelieved, my lord, for contradiction, due to contradictions, my lord. Para 4, my lord.
Let us see. 37. Ram Singh. Two judges. Prachi. Prachi. 1991. This judgment perhaps been not made aware of certain earlier judgments.
No.
Responsibility is on the council. Anyway. That is what I said, that there is also judgment that as if the other accused, who was also roped in by 34, was there, then your culpability is to be determined. Thereafter, conviction has to be rendered. If finding of guilt is reached, then since the other has already been acquitted, don't touch him. But this man must remain. There are decisions to that effect also.
Yes, yes.
Okay.
And my lord, this
Anything?
one more. Well, in this judgment, there is a line against the defense as well, my lord. But this is the judgment lordship is saying, my lord, the 34 part, my lord. Paragraph 10, my lord. Here, my lord, there were three accused, my lord. Father-in-law, mother-in-law, and the husband, my lord. Father-in-law, mother-in-law were acquitted, my lord. And the deceased was the wife, my lord. There are 10, my lord. It starts from, my lord.
I mean, repeatedly asking the question which has been asked here at the end of the paragraph 10 to
My
Mr.
lord.
Mahal.
Hello.
I've been repeatedly asking. Other than motive, what are the things the prosecution in this case was required to prove?
She was never mistreated, my lord. Never beaten by the husband, my lord.
Yes, there is all motive. That was the motive.
No one has seen, my lord, any untoward incident, my lord.
This BW 3, 4, and 5, these are to be meticulously, with care and caution, their case testimony is to be examined.
Well,
Yes, anything more?
yeah, para 11, my lord. Fourth line, my lord. It may be that the appellant was the primary or the main actor in the actual commission of the murder. After his stepmother has sought his aid in what appeared to be an appeal to him by her to teach his wife a lesson, so that she may not be troubled by her anymore. But the effect of the finding that the appellant went into the room, it goes on, my lord. But all this, lordship will see, my lord. But all this is a matter of conjecture and lurking, but not unreasonable doubts and suspicion seem to us to envelop and assail the prosecution case, at least after Jamuna Prasad and Kalavati have been acquitted. As the learned counsel for the appellant rightly pointed out, after the acquittal of Kalavati and Jamuna Prasad for murder by the use of section 34 Penal Code, the individual and not the conjoint liability of the appellant has to be established by the prosecution before the appellant to be convicted under section 302 IPC simpliciter. Beyond the fact that the appellant is the husband of the murdered wife, who might be ordinarily expected to take the initiative in teaching her a lesson, especially when Srimati Kalavati had invoked his aid, and a possibly natural reluctance of a normal father-in-law to take the initiative of leading role in such a matter, both of which could be matters of conjecture or presumption only. There is nothing which could fasten or conclusively fix the liability for any particular or separate act of the appellant, which may be said to have caused his wife's death. Paragraph 12, my lord, there is one line against me, my lord. Then 14, my lord. That 34 part, my lord. Paragraph 14, my lord. Mr. Mullah, appearing for the appellant, has also drawn our attention to KG Patil of state of Maharashtra. This court held that when two out of the three accused persons, each having been charged under section 3034 IPC, were acquitted, it must be assumed that the two acquitted persons did not participate in the commission of the offense at all. It is contended the natural result of this view is that the particular act of the individual accused which brought about the death of the murdered person must be established beyond doubt before he is singly and separately convicted under section 302 simply said that. Same thing is said in para 15 and 16, my lord. And then the finding is at para 17, my lord. Well, in this case, from the Honorable Supreme Court has said that, yes, the husband, we may have agreed with this conclusion on evidence on record that the appellant alone was liable for the murder of his wife Chanda Devi. And we may not have disturbed its finding of fact, but for another feature, the features were the one person was not examined, the second was the acquittal of the mother-in-law and the father-in-law. We may not have disturbed its finding of fact, but for another feature of the
Which
case,
paragraph?
para 12, my lord. This is the line against me, my lord. And nevertheless, we may have agreed with its conclusion on the evidence on record that the appellant alone was liable for the murder of his wife, Srimati Sonda Devi, and we may not have disturbed its finding of fact, but for another feature of the case which stares one in the face. One is that one lady was not examined, my lord. So section 114 adverse influence was taken, my lord. Second is that 8 of 34, two other co-accused were acquitted, my lord. So that is why the present that appellant was also acquitted. Because now who has done it, my lord? Because 34, who has done it, but that comes into doubt, my lord.
Yes.
The humble submission, my lord.
I have given Balbir Singh Lordship, where the mother is acquitted Lordship.
Yes.
Lordship in this
106.
para 11 and 12 Lordship, where the
11 and 12.
mother was acquitted Lordship. In the
Listen. Yes, 11, 12. 1 minute. Let the other copy come. Hmm. Hundred. 109. Yes, 11 and 10, 11 and 12, right?
11, 12, and lordship in the 13 lordship as a disease lordship, last part lordship. He was clearly asked that poison was found in the disease viscera examination report. What you have to say about it
Which
regarding
paragraph?
paragraph 13 last part,
Last.
lordship. He could not give a proper explanation, lordship. Same as
13 last.
same is the case, lordship, for regarding
Uh-huh.
strangulation. He could not give a proper explanation.
Paragraph 13 last.
Lordship. The accused Balbir Singh said that I do not have knowledge how it was found about the poison, lordship. In Balbir Singh case, lordship, it was regarding the poison, lordship. And in the present case, lordship,
No, where is the 13?
3 lordship,
1 3.
last part, lordship.
No, the paragraph starts with what?
Starts with lordship, last part accused statement
No,
was
the paragraph starts with what?
on
Word.
the trial court while holding the appellant.
Okay, that is there. Thereafter quoted. Many paragraphs were quoted.
Okay.
Which paragraph?
13 lordship, page number
There are many paragraphs quoted. Paragraph 21. See the second line itself.
lordship.
21, paragraph 21 quoted, 22 quoted, 23.
21
Four.
lordship, 21,
Tell me that.
21 last part.
21 last part.
This is regarding this explanation of strangulation. I am in your lordship in Section
Okay,
313 of the Criminal Procedure Code, he was clearly asked that poison was found in the disease viscera examination report. In this regard, he couldn't give any explanation also.
We are not getting it.
Paragraph 1321, Lordship quoted 21, disease died of poison or.
Where? Middle part, first part? Not last. Hmm. Mazot. 4 line and Pishot. 13 is running into at least 25, 30 sentences. You should have said that third sentence or fourth sentence.
Sorry.
There are about 30 sentences. Hmm. Yes.
Lordship, accused statement was registered under section 313 of Criminal Procedure Code, and he was clearly asked that the poison was found in disease viscera examination report. What regarding this, Balbir Singh said that I do not have knowledge how it was found. Same in the instant case, Lordship, regarding the strangulation, Lordship, he couldn't give a proper reply, Lordship.
Here he is not admitting the strangulation part. He is confessing that she died after because of that burn injury.
But when, Lordship,
However, he stated that he was dead.
question number 11, Lordship, of 313 of the present case, Lordship. There, Lordship, you stated before him that due to aforesaid altercation and you strangulate her with the help of the sari when she was wearing that page number 71, Lordship.
Which question?
Question number 11. Witnesses Syamanta Kumar Borua.
This.
Government Kaumura.
Which part?
Page 71, Lordship. This with first from second line onwards, Lordship. This witnesses declare hostile then, Lordship. So it's a prosecution admitted that you stated before him after that due to aforesaid altercation you strangulate her 71 from down below 1, 2, 3, fourth line. He simply said, Lordship, I do not know anything. That she died only of burn or like that.
The evidence of 13 was hit by 25 and 26 evidence, actually.
Name doc, question number 12 also lordship. Witness of Dr. Vikramjit Borua,
Hmm.
71, PW 14. That also he cannot, that on so and so, he examined and found 3 number of injuries over her body. In his opinion, the cause of death of deceased was due to asphyxia as a result of strangulation. And all the injuries sustained by the deceased were homicidal in nature and the time since. In that part also, Lordship, I do not know what the doctor had written in the postmortem. He has
What
not
was the age of the old lady?
65 to 70 years, Lordship.
62 years old, as per 313.
313.
Age 61, 62 years old. In the year 2016 minutes. So
62 years.
2010 occurrence, my lord. 56 years, my lord. Date of occurrence, my lord. He was not that old, my lord.
But you yourself projected,
also-
see, lying indisposed, incapable of doing something. You have done it.
PW5 minute. PW5 minute.
You have done it. Then another that ailing condition.
Yes, PW5 minute.
Your cousins have done it.
The ailing old
That
lady.
she is incapable of
She
doing
was
it.
56 years at the time.
So your cousins,
56 years at time of
your
occurrence.
cousins and Jathai had done it.
Zatai has said my hand is broken, my lord.
That is the shielding part.
No other witnesses have said that his hand is.
There is a thing separating the grain from the chaff.
Chaff. Oh, okay.
It would require separating the grain from the chaff. Yes, anything?
My humble submission, Lordship. Came in
Oh.
official. Because all are
Except motive.
chain of circumstances also complete.
What do you say about that if an offense takes place inside the privacy of a house in such circumstances? Or the assailants have all the opportunity to plan and commit the offense at the time and in circumstances of their choice. It will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstantial evidence as noticed above is insisted by the court. A judge does not preside over a criminal trial merely to see that no innocent person is punished. A judge is also presides to see that a guilty man does not escape. The law does not enjoin a duty on the prosecution to lead evidence of such character which is almost impossible to be led, or at any rate extremely difficult to be read. The duty on the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. Here it is necessary to keep in mind section 106.
Here I would rely upon my lord Novendra Sir and Sawal Das, my lord. And Sawal Das, my lord, acquitted under 302, but then convicted under 201, my lord. Because he did not tell people about the actual occurrence, my lord.
So moreover, Lord,
Hello, my
almost
humble-
70 days of marriage, Lordship.
My lord, my humble prayer is that it will always remain in doubt because she has been acquitted, my lord. Who did the actual, my lord, act, my lord?
Late
That
night,
is the-
Lordship, it is impossible for her.
That would be the benefit, my lord. Possibly, my lord.
We'll dictate tomorrow, second half.
Lordship.
As it home now. Anything more?
From prosecution side.
Lordship, he may not be allowed. His petition may not be allowed, Lordship, because it's 70 days and moreover, Lordship, all the evidence are.
Here you have only pointed out to the facts. What is the conclusion?
Lordship, I'll mark it, Lordship.
You have not read the whole.
No, I have, Lordship.
Tell me.
Lordship, page number, we take to notice of the fact that the appellant convict husband.
Police custody too. Hmm?
Fifty-three, Lordship. Para 53, Lordship. Same as we have projected, Lordship, that she died of poison. In the present case, she have projected that she died out of burning of the stove, Lordship.
Hmm? Mandaragiri? Mandaragiri? Itu case. Itu case. মাথা গরম হুম, হুম। Each of the judgments. 28. এই SCC পেৰাগ্ৰাফবোৰ হেৰি কৰি দিয়ে এইটো বলবীৰ সিংটো আমাৰ আছিল নহয় SCR ৰ পৰা SCR ৰ পৰা this your Sawal Das judgment has been distinguished
My lord.
by bringing in a new concept in the latest one. Balbir Singh. Sawal Das.
My lord. Always, my lord.
Right. That is what I was reading. I have not read totally, but that Sawal Das theory has been discarded.
Overall, my lord.
Not applicable because these reasonings that Sawal Das you referred to, this 8, 9, 10.
10, 11, 12, my lord, yes, my lord.
But 8, 9, 10 are also there.
8, 9, 10 it starts, my lord. 8, 9, 10, that 106.
These
has
are
to be-
submission and 10. This last part that has that prosecution recharge its initial and so and so. Distinguish করেছে বেলা একটা কনসেপ্ট আনি মর্গেন্দ্র স্যার হ্যাঁ বলবিটো হ্যাঁ বলবিটো We put it on Monday then,
Monday.
parted, because some matters are there.
Tomorrow, Bhuya, Miss Bhuya have made that Nalbari.
Mia is not available.
No, she is available. She will be there, Lordship. That the
Oh.
case Lordship have to Lordship
Okay.
27 years
Hmm.
behind the bar. Concurrently all consecutive.
Concurrent,
Lordship,
consecutive.
consecutive.
Okay. And Mahajan, appellant. A Begum. Respondent state. At least that is appeal for hearing again on Monday as parted.
No, I beg my lord's pardon, my lord. Sawal Das I placed because in
We'll see. We'll read this.
Gargi also it was relied upon. That is why I placed. my lord.
We'll read.
Yeah.
I have just had a glance. Sawal Das was
It was in
somewhat.
In Gargi also,
Somewhat-
that is why I placed. my lord. Because Gargi 2023 had
Sawal Das has been deviated from
Okay.
in Balbir.
Because Gargi relied upon. That is why only
I have to read. I have to read.
Beg my lord's pardon, but I did not know. my lord.